It's Public Service Commission file number WA-2021-0376. And it also entails file number SA 2021-0377. And the two files have been consolidated for this hearing. My name is Ken Sire, and I am the regulatory law judge presiding over this hearing. The hearing is taking place in the Public Service Commission hearing room, room 310 of the Governor Office Building in Jefferson City, Missouri. However, counsel and witnesses will also be participating over the internet via Cisco WebEx. Let's have counsel for the parties make their entries of appearance, beginning with Missouri American Water Company.
Thank you, Your Honor. Dean Cooper from the law firm of Bryden, Swearingen, England, PC, PO Box 456, Jefferson City, Missouri 65102, appearing on behalf of Missouri American Water Company.
All right. On behalf of the public counsel?
Nathan Williams, Chief Deputy Public Counsel, appearing on behalf of the Office of the Public Counsel and the public. My address is PO Box 2230, Jefferson City, Missouri 65102.
And for the staff of the commission?
Karen Brett, BRETV, for staff of the commission. My address is 200 Madison Street, 8th floor, Jefferson City, 65101.
Thank you. For those in the hearing room, yes.
If I may, I barely heard staff counsel.
Oh, do you have your microphone turned off?
It's on. I'll speak more into it. Oh, there we go.
Do you want to go ahead and repeat?
Sure.
Oh, that's not necessary. I just wanted to make the commission aware.
All right, thank you. For those in the hearing room, I do ask everyone to silence all cell phones and mobile devices. For those connected via Cisco WebEx, I ask that you mute your microphone when not speaking. Also, for those in the hearing room, please be cognizant, like Ms. Bretz, of when your microphones are on, indicated by the green light, and when they are off. Please be aware that practically every grunt, groan, and page rustle will be picked up by those microphones. Let's see. As a courtesy, I'm sorry, excuse me. Oh, there are a few preliminary matters I'd like to address. Mr. Linton, are you still here in the room? Yes, okay. David Linton is here on behalf of the Jefferson County Public Sewer District. But Mr. Linton, it's my understanding that that you do not intend to stay for the hearing, and that your witness, Douglas Bjornstad, you've also asked that he be excused from the hearing. So do any of the parties have any objection to that? Okay, I'm seeing shaking heads, and so Mr. Linton, you are, and your witness are excused from the hearing.
Thank you, sir.
All right. Also, on the joint list of issues that the parties filed, issue number 2 states that if the commission grants Missouri American Water Company's application for the CCNs, A, what conditions, if any, should the commission impose? And B, of which service areas should the Eureka water and wastewater systems become a part? Now, looking at the statements of position that were filed by the parties, it appears to me at least that the company and staff are in agreement as to those issues, the conditions to be imposed and the service areas. Am I correct about that?
Yes.
I believe that's correct.
All right, thank you. All right, do the parties have any preliminary matters they'd like to address? Okay. I'd like to go over the witness list as far as the order of the witnesses and make sure that there are no additions to the list that was previously filed. For the company, Mr. Cooper, I show Sean Flower, and I understand I'm sorry, I'm getting my witnesses mixed up. Will he be here in person or?
He is here in person.
Okay. Followed by Mr. Joseph Batis.
And he will be appearing via WebEx.
Brian Eisenloeffel. Leffel?
Yes, the rest of our witnesses are here in person. Mr. Eisenloeffel, Mr. Kaiser, Ms. Simpson, and Mr. Grant.
All right. And there's no additions to that list as far as what had previously been filed?
No.
All right. And then for the staff?
So our first witness is Kurt Gately.
Okay.
And then, as we discussed, Mr. Harris and Mr. Bruce are unavailable, so we'll figure out later how to deal with that. Mr. Buddig is here, Ms. McMillan is here, and Mr. Glasgow will be on WebEx.
Okay. As far as exhibits go, have all exhibits been pre-marked?
We have supplied our hard copies of exhibits 1 through 12 to the court reporter.
Okay.
I have them here. I haven't supplied them yet, though.
Okay. All right, I do have a question for the parties. Do either party, or does either party plan to offer into evidence or plan to ask the commission to take notice of the 2021 Uniform Standards of Professional Appraisal Practice?
We would like to do that, yes.
Okay. And so, yeah. And so that's something that you have here today?
Yes, I have copies of
Okay.
that.
All right. There are also a couple of matters I'd like to discuss with the parties. The commissioners are interested in whether the parties have had prior cases involving acquisitions under Section 393.320 of the Missouri statutes. If that's so, will the parties have a witness or witnesses here to testify during the hearing as to those prior cases? Or can you make witnesses available before the close of the hearing?
The answer for the company, Your Honor, is that yes, at least the Lawson, Garden City, and Oric cases for Missouri American Water Company were processed under 393.320. It might depend upon the question which of our witnesses would be the most appropriate to answer it, but I'm sure that one of our witnesses, or maybe more than one of our witnesses, could handle those sort of questions.
Okay.
And for staff, if we can make witnesses available, that if we could know in advance the scope of the questions, the nature of the questions, that might be more helpful to make sure that we have the right witness for the commission.
All right. The commissioners also have questions regarding the sales comparison approach to determining the value of a utility. Those questions focus on the sales metrics used. For example, the sales price per customer, the sales price per million gallons per day treated, et cetera. Can you tell me who would be the most appropriate witness or witnesses to testify on that topic, Mr. Cooper?
For the company, I believe it would be Mr. Bates.
Okay.
For staff, Your Honor, I think Amanda McMillan could address that, and perhaps also Mr. Gately.
thank you. All right. Are the parties ready for opening statements? Cool. Okay. All right, before we get into opening statements, Chairman Sylvie is here today. Would the other commissioners identify themselves? Let us know they're here for the hearing.
Thanks, Judge. This is Commissioner Holzman. I'm on.
Commissioner Coleman is here.
All right. Thank you, commissioners. All right, Mr. Cooper, would you like to present your opening statement?
Yes, Your Honor.
Thank you.
Your Honor, what I handed out
Mr. Cooper, I'm not sure that that microphone's on.
doesn't seem to be, does it?
Now it's.
Hello. Hold on. I can do this from.
It sounds like it's on when you touch the microphone. It does not sound like it's on when you
my
begin
voice is
talking.
going through it.
Yeah.
Can the phone hear?
Can anyone there on WebEx hear, Mr. Cooper?
It's
I
extremely
can.
faint.
If that's all right with you, yes.
This is better, Judge.
Yes.
What I have handed out is what would have been a PowerPoint on the board, but I think given our circumstances here in the room and on the WebEx, I have both handed out hard copies of that PowerPoint, and I emailed to you, Judge, a copy as well, and I emailed a copy to Mr. Williams as well. So if others are interested, if you would like to forward it to any of the commissioners, that would be wonderful.
All right. Why don't you give me a second to do that?
Commissioner Kochmeyer's here.
Morning, Commissioner.
Good morning.
It's Judge Sire. All right, Mr. Cooper, you can proceed.
Thank you, Judge. This case primarily concerns the application of Section 393-320 of the revised statutes in Missouri, otherwise known as the appraisal statute, to a transaction between the City of Eureka and Missouri American Water Company that had its origin in 2019. Eureka and MAWC have relied specifically on that statute, which is designed to encourage consolidation of small water and sewer systems into larger systems having greater economies of scale and resources. Section 393-320 applies where the buyer, Missouri American in this case, is a large water public utility that provides safe and adequate service, and the seller, again in this case Eureka, is a small water utility. There is no dispute in this case that MAWC's and Eureka's water and sewer systems separately qualify. The City of Eureka and MAWC signed a letter of intent to explore a potential acquisition in July of 2019 to include an agreement to pursue an appraisal of the system. That appraisal was completed in March of 2020 by 3 certified general appraisers under Chapter 339 of the revised statutes of Missouri, who additionally have specific qualifications in utility appraisals. On May 19th of 2020, Eureka Board of Aldermen passed an ordinance providing notice of an election to vote on Proposition S, a question as to whether the water and wastewater utility owned by the City of Eureka should be sold. The specific question on the ballot is found on the second page of that PowerPoint that I handed out, but it states, shall the City of Eureka, Missouri be authorized to sell its water and wastewater, begin sewer and utilities to Missouri American Water Company for the sum of $28 million. The election was held on August 4th of 2020, and a majority of votes cast were in favor of the sale. Proposition S garnered 2,289 yes votes, or 67%, to 1,127 no votes, or approximately 33%. Thereafter, on November 17th of 2020, MAWC entered into a purchase agreement with Eureka. This application was later filed in April of 2021. Missouri American requests in this case certificates of convenience and necessity to provide water and sewer service within the identified service areas in and around the City of Eureka, utilizing the Eureka systems. And as you probably have come across, Judge, we filed a stipulation primarily with Jefferson County District that doesn't further identify, but agrees to an identified legal description and map for those service areas. The Commission may grant a water or sewer corporation a CCN to operate after determining that the construction and/or operation are necessary or convenient for the public service. The Commission articulated criteria to be used when evaluating applications for utility certificates of convenience and necessity in the case NRA Intercon Gas, Inc. And those factors are commonly referred to as the Tartan factors. They are shown on the following page in the PowerPoint slides. In this case, we believe there is a need for the service as residents in and around the City of Eureka currently make use of the existing water and sewer systems. And in fact, Eureka is the last remaining municipality in St. Louis County that still operates its own water treatment and distribution system and its own wastewater system. MAWC is qualified to provide the service, as it already provides safe, adequate, and compliant water service to over 470,000 Missouri customers and sewer service to over 15,000 Missouri customers. Missouri American Water Company has the financial ability to provide the services. The Commission has indicated previously that positive findings with respect to the other 4 standards will in most instances support a finding that an application for a CCN will promote the public interest. The factors for granting certificates of convenience and necessity to Missouri American in this case have been satisfied, and it is in the public's interest for Missouri American to provide water and sewer service to the customers currently served by the City of Eureka. Further, MAWC possesses adequate technical, managerial, and financial capacity to operate and improve the water and sewer systems it wishes to purchase from the city. Thus, the commission should authorize the transfer of assets and grant MAWC the certificates of convenience and necessity to provide water and sewer service within the proposed service area. Staff argues in the memorandum that is a part of Mr. Gately's testimony that the transaction as requested by MAWC in its application, i.e. utilizing the appraisal method contained in section 393-320 RISMO, is not in the public interest. If you'll look at the following page in the slide deck, there's a quote from a commission case in the matter of the joint application of Great Plains, KCPL, and Aquila from a report and order. And in that section, the commission stated in part as follows as to the public interest. The public interest is found in the positive, well-defined expression of the settled will of the people of the state or nation as an organized body politic, which expression must be looked for and found in the Constitution, statutes, or judicial decisions of the state or nation. In this situation, the public interest has been expressed through statute, that being section 393-320, the appraisal statute. Utilizing that statute cannot be contrary to the public interest. Staff witness McMillan further seems to suggest in her rebuttal testimony that staff's estimate of the net book value is a more appropriate basis to establish the value of the acquired City of Eureka properties than the sales comparison approach used by Missouri American. Essentially, staff is arguing that its after-the-fact calculation of net book value is a more appropriate measure of the value of the system than the appraised value. Of course, net book value is not mentioned in section 393-320 and is very different from the fair market value that is referenced by the statute. Moreover, as already discussed, the decision as to whether net book value or fair market value is a more appropriate basis of establishing rate-making rate base in this situation has already been made by the General Assembly. Use of the appraisal is mandatory, not discretionary under the provisions of section 393-320. And again, if you'll turn to the next page of the slide deck, the next 3 pages actually are some quotes from that statute, which indicate that the procedures contained in the statute may be chosen by a large water public utility, and if so chosen, shall be used by the Public Service Commission. Subsection 5 on the next page indicates that the lesser of the purchase price or the appraised value, together with the reasonable and prudent transaction, closing, and transition costs incurred by the large water public utility, shall constitute the rate-making rate base. And on the next page, there's section 8, which says this section is intended for the specific and unique purpose of determining the rate-making rate base of small water utilities and shall be exclusively applied to large water public utilities and the acquisition of a small water utility. I would note that the use of water in that statute is interesting in that it clearly applies to both water and sewer, but the statute refers to those entities in that fashion nonetheless. This approach makes much sense given that municipal systems such as those of Eureka have no net book value as that term is used by the commission. The books and records of a municipality are greatly different from those of a regulated Missouri utility. In fact, Missouri American would suggest that this is one of the reasons that the appraisal statute is necessary. Similarly, aspects of the net book value calculation are just plain inapplicable to a fair market value analysis. For example, plant assumed to have been contributed, or to have CIAC as the regulatory world refers to it, and plant assumed to be fully depreciated would have no net book value. However, it's common sense that fully operational plant that is providing service to customers on a daily basis does have value for purposes of sale at fair market value. In this case, the purchase price, which was specifically identified in the public election held in Eureka, is equal to the appraised value. That amount, together with the reasonable and prudent transaction closing and transition costs incurred by Missouri American, the statute indicates shall be used by the Public Service Commission and shall constitute the rate-making rate base. Staff also attached the appraisal itself. The statute requires certain things, and again, on pages 8 and 9 of that slide deck, we reproduced that part of the statute. The appraisal in this process, in this case, followed the statutory requirements to include the use of 3 appraisers, all of which are certified general appraisers under Chapter 339, among many other qualifications. Staff, without the benefit of the testimony of any certified appraiser, tries to allege deficiencies in the appraisal completed in March of 2020. Staff primarily alleges that MAWC's intended plans for the water system should have been taken into account, that certain MDNR reports associated with the sewer system, and I would emphasize that this applies only to the sewer system, undermine the high-level review of the condition of that sewer system, and that MAWC should have negotiated a lower purchase price. All of these matters are specifically addressed in Missouri American's sewer rebuttal testimony, among other issues, and none of those arguments change the validity of the appraisal conducted by the certified appraisers. As was mentioned previously, the company has no objection to the conditions proposed by staff should the application be approved. And additionally, Missouri American takes the position that Eureka's now approximately 4,100 water customers should be added to the St. Louis County customer base of approximately 343,000 customers. And on the sewer side, Eureka's approximately 4,100 customers should join the other Missouri sewer rate category of approximately 8,500 customers. Missouri American believes that given the relative size of the St. Louis County Water District and the other Missouri Sewer District, the impact of the acquisition and the addition of the approximately 4,100 customers for each water and sewer, and the appraised rate-making rate base for Eureka will have a de minimis impact on the existing St. Louis County water customers and be a measurable benefit for the other Missouri sewer customers. As a result of these matters, Missouri American asked the Commission to grant it the water and sewer certificates of convenience and necessity requested in this case, subject to the conditions proposed by the staff, and set the rate-making rate base for the Eureka water system at $18 million and the rate-making rate base for Eureka sewer system at $10 million, plus reasonable and prudent transaction closing and transition costs, as called for by Section 393-320. That's all I have, Your Honor.
All right. Thank you, Mr. Cooper. Mr. Williams, would you like to make an opening statement on behalf of the public council? Question.
Briefly,
I'm
thank
sorry.
you.
I'm sorry. Before we go there, I'll give the commissioners an opportunity to ask questions. Chairman Silby?
Thank you. Just a couple questions. And you mentioned it on several different pages of your PowerPoint, but just to be clear, does the commission have the authority to take any action other than approving or rejecting the application?
I'm more challenged by that than maybe I should have been. I probably would have to reflect more on it, Chairman. I think that is probably true, however, that given the wording of 393-320, that there's not really a middle ground in this case.
Okay, and does the commission have the legal authority to set a rate base at an amount different from the appraisal?
I would say no. I think that 393-320 is fairly straightforward in terms of what it directs the Public Service Commission to do in this situation.
If the commission is persuaded by staff's arguments that the appraisal is deficient, what authority do we have as it pertains to the appraisal?
Well, I'm thrown a little by the word deficient, because I think that if it were truly an unlawful appraisal, I think that the commission could find that. I think that if by deficient someone said, I would have appraised it differently, or perhaps they should have done X, or maybe could have done Y, I don't know that that makes it unlawful.
So by unlawful, the commission would have to find that one of the three appraisers was not a disinterested person? Is that the only way that it could be unlawful?
That's certainly the most obvious, I think. The statute also says, shall be in conformance with Missouri law and the uniform standards of professional appraisal practice, which we certainly believe that the appraisal in this case is.
So apart from those two areas, appraiser in good standing with Missouri practices and disinterested, those are the only two things that are required for the appraisal itself to be a legal appraisal.
That would be my understanding, yes, Chair.
Okay. Thank you, Judge. I have no further questions.
Thank you, Chairman. Do any of the other commissioners have questions?
No questions, Judge. Thank you.
Same here, Judge. No, thank you.
All right, Mr. Williams, now I believe we're ready for your opening statement.
Thank you. Public counsel has not taken a position as to whether or not the commission should grant a certificate in this case at this point in time. However, really the ultimate question the commission's faced with is the public in Missouri as a whole better off if Missouri American Water takes over and operates Missouri Eureka's water and sewer systems? And part of the analysis should include, or must include, the impacts on rates because of the appraisal statute. If it were not done because of the appraisal statute, it would be done if there were an acquisition premium. And that's actually been litigated in the past whenever Great Plains Energy acquired Aquila. There's a case out there, State XRL Ag Processing Inc. versus PSC at 120 Southwest 3rd, 732, Missouri Bank, 2003. As to Chairman Sylvie's question about whether or not the commission can do anything in terms of, does it just have to approve the application or reject it? In other words, issue a certificate or not? 393-170 gives the commission the authority to impose conditions on a certificate. The parties, well, Missouri American Water and staff have agreed to certain conditions, but that list need not be exhaustive. In other words, the commission could impose other conditions should it desire. The only other thing I'd like to point out is what I said in this position statement, that for negotiating a purchase price, there's really no incentive for either Missouri American Water Company or the city of Eureka to minimize that price. Certainly the city wants to maximize it, but there's really no incentive on Missouri American Water to minimize it. And that's all I have. I'd be happy to take any questions.
Chairman Sylvie?
Thank you. I would just like to follow up. Does public counsel agree with company's counsel that the commission does not have the legal authority to set a rate base at an amount different from the appraisal under the statute?
That's an interesting question. I don't know that anyone's ever litigated exactly how that statute works. In fact, I believe it has not. I think all of the cases that were mentioned, and I think the city of Bolivar is involved this statute as well, were all resolved by settlement. I could be wrong about that. But in any event, I don't believe that question's arisen, and I don't know if it's the commissioners or a court where someone would challenge, I guess, the underlying appraisal that's being used to support the rate-based treatment. But aside from that, it seems to me if the appraisal's legitimate, then the statute's clear on its face.
And then to follow up on what you just said, what is public counsel's opinion of what would make an appraisal illegitimate?
I don't know. I think it's one of those things I would need to see it. Certainly collusion. And I'm not asserting or claiming that any of that applies in this case, certainly.
Sure, and I don't believe anyone is necessarily just questioning what the parameters would be to find an appraisal illegitimate.
Frankly, I haven't researched that issue. I don't doubt that the sufficiency of appraisal's been challenged in other contexts, condemnations, for example. But I'm not familiar with that. Certainly something different than what the matters I've seen before the commission in the past.
Okay, thank you, Judge. Thank you.
Do any of the other commissioners have questions? All right, hearing none. Ms. Bretz, would you like to make an opening statement?
Yes, please, and if it's okay, I'll stay seated as well.
That's fine.
It seems to be working better. Good morning, may it please the commission. I'm Karen Brett, representing commission staff. Missouri American proposes to purchase the city of Eureka water and sewer assets. Each utility has about 4,100 customers. Missouri American and Eureka received an appraisal valuing them at $28 million, which is divided as the water system at $18 million and the sewer system at $10 million. Eureka voters voted in August 2020 to sell their utilities for $28 million, and Missouri American and Eureka executed a purchase contract in November 2020 to purchase them for $28 million. Missouri American's other customers did not vote on this and were not permitted to vote on the acquisition. Central to this case is the appraisal statute, 393.320 RISMO. This is not the first time that Missouri American has purchased small utilities using the appraisal statute, but this is the Commission's first opportunity to substantively consider its parameters. The process described in the appraisal statute requires the large utility and the small utility to each select an appraiser, and these two appraisers select a third one. The statute says that each of the appraisers, quote, shall be a disinterested person, end quote. The reason for this is to have a neutral process. The appraisers are to jointly produce an appraisal. Missouri American has made only one of the appraisers, Mr. Beatties, available today. The appraisal statute's purpose is to facilitate large utilities purchasing small, typically ailing utilities. That's what we have here. Missouri American is a large utility seeking to purchase the water and sewer assets of the city of Eureka. The sewer system is ailing. It's under Missouri Department of Natural Resources enforcement for not meeting effluent limitations, and it regularly has sanitary sewer overflows. Kurt Gately, staff manager for water, sewer, and steam, is available to answer questions about policy, staff's investigation, and DNR compliance. Although the water system is in compliance with DNR, there are aesthetic issues with it, so that if the sale goes through, Missouri American intends to build a pipeline from St. Louis County to Eureka to provide a new source of water. In other words, the assets that Missouri American proposes to purchase for $18 million will be relegated to purchase a mere backup system that will be largely redundant. If this transaction is approved, the Eureka water system will be incorporated into Missouri American St. Louis County service area. Missouri American proposes to charge all these customers the full $18 million for a backup system for its 4,100 Eureka customers. How is this fair? The Commission is aware that staff engineers Andrew Harris and David Roos are unable to testify this week. At a later time, they can further discuss the system's conditions based on their physical inspections and review of reports. How did Missouri American arrive at a value of $28 million? As I stated earlier, the appraisal statute requires 3 disinterested appraisers to produce an appraisal. Here, the 3 appraisers hired Flynn Engineering to assess the utility's condition, calculate their 2019 estimated cost, and then depreciate them based on the Missouri American approved depreciation schedule. The engineers produced 2 studies. The first is dated January 18th, 2020, and the second is dated March 16th, 2020. The first engineering study values the water system at $10.5 million and the sewer system at $5.5 million for a total of $16 million. Interestingly, this is $2 million less than staff's calculation of net book value. Also interesting is the number of emails between Missouri American and Flynn Engineering during the report writing process. This is interesting because Missouri American is not the client. The appraisers are. The appraisers hired Flynn Engineering to produce a report. These emails show that Missouri American personnel were involved in creating the Flynn Engineering report. How can this possibly be considered neutral? As I stated earlier, the first engineering report is dated January 18th, 2020, for a total estimated value of $16 million. A few weeks later, on February 7th, 2020, Derek Lynham, Missouri American engineering manager, and Kelly Simpson, a professional engineer at Flynn Engineering, exchanged a series of emails to arrange a meeting. Ms. Simpson writes to Mr. Lynham, quote, "I'll come to your office and bring everything on my laptop. We can test various assumptions live on the spreadsheet and see what it does," end of quote. Mr. Lynham writes back, quote, "Sounds good, thanks," end of quote. There was another email exchange a few days later on February 10th. Mr. Lynham at Missouri American writes to Ms. Kelly, quote, "Here is a crude spreadsheet I put together of parcel data, your built, that we can discuss. Thought I would send it to you to look at before our discussion. Again, just wondering how a newer system assumption will impact depreciated value for the water and wastewater distribution and collection systems," end of quote. These emails illustrate Missouri American's involvement in creating the Flynn Engineering report. This cannot be the neutral process that the legislature envisioned in passing the appraisal statute. The second Flynn report is dated March 16, 2020. It values the Eureka utilities at $31.5 million, which is almost twice the original amount. Missouri American's explanation for the differing report is that for the second report, it provided Flynn with more accurate GIS data about the assets' ages. However, Flynn Engineering did not offer an explanation in the second report why it revised its numbers from the first report. Flynn did not even mention the first report in the second report. Again, this causes staff to question how neutral this process was. According to its engineering report, Flynn based its valuation of the above-ground assets on insurance values. Flynn made no independent valuation of them because Flynn didn't inspect them as part of preparing its reports. Ironically, while Flynn was hired to be the consulting engineers for this project, Flynn never visited the site before writing its reports. Flynn based the replacement cost of the below-ground assets on information from the City of Eureka vendors and contractors. For both reports, Flynn determined the asset's current cost, then depreciated this based on Missouri American's approved depreciation schedule. What the emails between Missouri American and Flynn, and also the emails between Flynn and the appraisers, do not show is consideration of the utility's condition. There is no substantive discussion of the asset's condition, repairs that need to be done, the status of DNR enforcement action, or whether the systems are even meeting DNR standards. The Flynn report is full of fuzzy language about condition. For example, on page 4 of both reports, Flynn writes, quote, "The water distribution system was not observed for condition. Based on the condition of the above-ground assets, it is assumed that the water distribution system is also well maintained and is assumed to be in good condition, end quote. On the next page, Flynn writes the same about the sewer collection system. More fuzzy, unhelpful language is on page 4 of both reports. Flynn states about the sewer lift stations, quote, since they are still in operation and could continue to stay in operation well beyond the depreciation period, it is assumed they are in good condition. End of quote. What does this mean? Missouri American acknowledges that if it acquires a sewer system, it will invest $350,000 for wastewater lift station replacement. Although this isn't a great deal of money, it certainly raises the question of condition, which Flynn dodges. The appraisers relied on information in the Flynn report to perform their appraisal. Staff's position is that the appraisal is flawed on numerous levels and does not provide an accurate value of the asset. There are different ways of appraising. Using sales comparisons is one method, another is the cost approach. As its name implies, the cost approach looks at the cost of construction, less depreciation. This is what Flynn engineers used to value the system. The appraisers looked at the sales of other small systems on a per customer basis to assign the Eureka assets per customer values. For example, the most expensive water system on a per customer basis that the appraisers looked at is the village of Sydney in Illinois near Champaign. Illinois American purchased the system for $2.3 million, and it has 567 customers. It's substantially smaller than the Eureka system. 2.3 million, this is for the water system, 2.3 million divided by 567 equals $4,056 per customer. This was the most expensive system on a per customer basis that the appraisers looked at. Based on this, the appraisers assigned an even more expensive per customer value to the Eureka water system at $4,500 per customer. $4,500 multiplied by, at that time, 4,009 Eureka customers equals just over 18 million. The appraisers didn't look at any comparable sales of small water systems at $4,500 per customer. The highest, again, the village of Sydney, was almost $500 less than what the appraisers assigned to Eureka. The appraisers didn't explain why the Eureka system is worth so much more than the next most expensive system. The Commission lacks information about this comparable to determine whether it's a valid comparison. And what's the point of using comparable sales anyway, when the appraisers just picked a number higher than any of the comparables? For the Eureka sewer system, the appraisers looked at sales of small sewer systems and determined a per customer value of $2,500. $2,500 multiplied by 4,000 is almost 10 million. Staff's position is that the sewer system appraisal is flawed, and the Commission should reject it. The appraisal does not satisfy the requirements of the appraisal statute and should not be evidence of rate-making base. This is because the appraisal takes no consideration of the sewer system's condition. Although the appraisers relied upon the engineers to report on the system's condition, the engineers never visited the site before writing their reports. Crucial to determining value is consideration of the property's condition. That's what you hire an appraiser to do. It's self-evident that a component that is running well and is meeting regulatory requirements is worth more than one that is not. The appraisers relied upon Flynn Engineering to deliver a professional opinion whether the assets are operating as they should by delivering safe and adequate service. Flynn Engineers did not deliver. Regarding the water system, staff believes that $18 million is too high for a system that will be largely a backup system. Missouri American has stated that shortly after the sale, it will construct a pipeline to deliver water from a different source due to aesthetic issues with the water. By failing to address future use, the appraisal is irrelevant to the 393.170 RISMO analysis, which is prospective in scope. Although Missouri American carries the burden to prove that this proposed transaction is necessary or convenient for the public service, Staff proposes its estimate of net book value as a comparison to Health the Commission. As part of this investigation, staff inspected the systems, examined records from Missouri American and the city of Eureka, as well as publicly available DNR records. It also reviewed Missouri American's application, its studies, responses to DRs, and calculated the Eureka system's net book value as an estimate. Staff engineer David Buddig used asset information in Missouri American's feasibility study and the Flynn engineering report to calculate net book value. He also calculated depreciation based on the Commission's approved depreciation rates and the amount of contributed plants to calculate an estimated net book value. Amanda McMillan took Mr. Buddig's information and compared it to the appraised value. Staff's calculation of estimated net book value is $10.7 million for the water system and $7.1 million for the sewer system, for a total of almost $18 million. This is about $10 million less than the appraiser's valuation. As I just stated, staff's calculation of net book value is based on Missouri American's own list of assets and original costs. Also, its methodology of calculating rate base here is the same as it uses in rate cases. Eureka needs water and sewer service. Missouri American is qualified to provide the service, and it has the financial ability to provide it. Missouri American's proposal to take over the systems is economically feasible. However, the acquisition will not be in the public interest because the system's inflated price will be paid by ratepayers in Eureka as well as those outside Eureka in the service areas that absorbs these systems. Missouri American seems to believe that the appraisal statute takes away commission discretion, so you must approve this transaction. According to this line of thinking, the commission does not determine whether the transaction is necessary or convenient for the public service as required by 393.17 RISMO. This would make the commission's role basically as a rubber stamper to approve Missouri American's application. Repeal by implication is disfavored. The commission retains full authority under 393.170.2 RISMO to determine whether granting Missouri American CCNs is necessary or convenient for the public service. The only authority the commission loses under this appraisal statute is the authority to set rate base. Staff sees the commission's role differently. We believe that the appraisal statute cannot be read in a vacuum. The transaction must still be in the public interest. If the commission determines that the transaction is not necessary or convenient for the public service, it cannot approve these acquisitions. All of staff's witnesses that I mentioned, plus Scott Glasgow from customer experience, will be available for cross-examination and any commissioner questions. Thank you.
Chairman Selby, do you have questions for Ms. Bretz?
I do, thank you. So we'll just start with the couple, like I asked the other, just for the record. So does the commission have the authority to take any action other than approving or rejecting the application?
Our position has been that it's an either-or thing, that that we have asked the commission to reject the application. We were discussing this yesterday with staff, and having said that, I think we would perhaps prefer to have a little bit more time to consider a more nuanced answer. But our position through all this has been that it's either reject or accept.
Okay. And does staff believe that the commission has the legal authority to set a rate base amount different than the appraisal amount?
I would say the same answer. If the commission rejects the application, that should be the end of the road. But we would appreciate the opportunity to reflect on it some more and perhaps have a more nuanced answer.
Okay. Did staff review the Illinois statute that Missouri American references, and if so, were there differences?
Yes, I believe that witness Amanda McMillan she's certainly more familiar with the statute than I am, and she could perhaps speak better to how that's different than Missouri.
Okay. And then some questions directly related to your opening statement. You mentioned some email traffic. Is that email traffic in the record?
No, we received that in response to DR responses. We do intend to introduce those into the record.
Okay. And who initiated that email traffic? Was it the engineers asking for more information, or was it the company proactively reaching out to the engineers?
It basically went both ways. There was a lot.
Somebody had to start it. There had to be an initial email.
Could you repeat your question?
Who initiated the conversation? Was it the engineers asking the company for more information, or was it the company seeking to proactively have a conversation with the engineers?
I guess I'd have to review that to see exactly where it started. But there was a lot of back and forth both ways.
Okay. You also mentioned that there was a public vote in this case, and you made the comment that the remaining rate base was not allowed to participate in that vote. Is that normal? I mean, I feel like I've seen several cases where the public voted on being acquired or not, but I don't recall ever seeing the entire rest of the rate base participating in that kind of a vote.
What I meant is that the city of Eureka voters voted on it, and if the transaction goes through, at least the water system will be incorporated in St. Louis County, but the St. Louis County voters didn't have an opportunity to vote on selling the Eureka assets.
Sure, but is that a normal process? I don't recall ever seeing more than just the people who are being acquired voting on something.
Yes, this was the normal process, of course. And my point is that particularly because of the inflated price of the system, it's unfair for the other people of St. Louis County to take on the burden of the system.
Okay. And then staff's position is they would like the commission to just reject the CCN. Correct? Right,
That's what we have asked, yes.
okay. But the system is currently a failing system that's not in compliance with DNR, is that right?
I don't think I can commit to saying that it's a failing system. I think saying it's ailing is perhaps more accurate. Mr. Gately could probably speak much better than I can to the status of the system.
So if the commission rejects the CCN, that system just continues in its ailing and or failing status?
Of course, the commission is concerned about that sort of thing. I believe staff has always been open to speaking with Missouri American about trying to reach a different price for the system. I'm sure those conversations would continue to try to figure out a way to move forward that would work out for all the parties.
Okay, thank you. Thank you, Judge.
Are there any other questions from the commissioners?
Not at this time, Judge. Thank you.
No questions, thank you.
Could the commissioners identify themselves?
Oh, I'm sorry. Yes, the court reporter has asked that the commissioners identify themselves before they speak. So that was Commissioner Kalkmeyer, correct? Commissioner, you may.
And Commissioner Holzman, I also said no questions. And from here on, Judge, I'll pipe up if I have a question. Otherwise, I'll be quiet.
All right, very good.
And likewise, Kochmeyer, like Holzman. If I have any questions, I'll notice up.
Gotcha. All right. Ms. Bretz, I do have a question or two myself. When it comes to the data request responses that you mentioned in your opening, are those parts of exhibits that you've listed and intend to offer into evidence?
Yes, they are.
Okay. All right. Actually, that may be my only question. All right. Mr. Cooper, would you like to call your first witness?
We would, yes, Your Honor. We would call Mr. Sean Flower.
All right. Mr. Flower, would you take the stand, please? Yes. All right. I'd like to swear you in before you testify. Would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Cooper.
Thank you, Your Honor. Mr. Flower, would you please state your name for the record?
That's Sean Flower.
By whom are you employed and what capacity?
I'm the mayor of the city of Eureka.
And are you appearing today on behalf of the city of Eureka?
Yes.
Have you caused to be prepared for the purposes of this proceeding certain direct and rebuttal testimony in question and answer form? Is it your understanding that that testimony has been marked as Exhibits 1 and 2 for identification?
Yes.
Do you have any changes that you need to make to that testimony at this time?
No.
If I ask you the questions which are contained in Exhibits 1 and 2 today, would your answers be the same?
Yes.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, at this time, I would offer Exhibits 1 and 2 into evidence and tender the witness for cross-examination.
All right. Are there any objections? All right. Exhibits
No
1 and 2
objection.
are, all right, sorry. Exhibits 1 and 2 are admitted. All right, Mr. Williams, do you have questions for the witness?
Just a few, I think. Good morning, Mr. Flowers.
Morning.
Mr. Williams, could you hold on for a second? Is that,
Sure.
Mr. Flowers, is the green light on your microphone?
I don't even know if I know where it is. Because there's nothing around the base.
Oh, I don't. All right.
Oh.
Yeah.
You may pull it up a little bit. It sounds like it's on.
Sounds like it's on.
Okay. All right.
Go ahead.
Mr. Flower, do you have any knowledge of the engineering report that Kelly Simpson is the witness for in this hearing?
I've read through all the documentation at different stages. I mean, I'm not an expert on it, but I'm generally aware, I'm familiar with it.
Well, Ms. Simpson testifies, it's not been admitted into evidence yet, but that someone made her aware of GIS data relevant to that engineering report. Do you have any knowledge of who made her aware of the GIS data?
I never got into any of that type of level. I'm hearing it, about how the discussions have gone on, but I don't have any direct knowledge of, of how the discussions came out about GIS.
Well, you're aware there were discussions about GIS data?
I am now, as we've gone into the hearings and that type of thing, I was aware of what they've done, kind of how the conversations were going.
When did you, I'm sorry, did you say you were not aware whenever the conversations were occurring?
I was not, I had nothing to do with no knowledge of any conversations, anything was happening. We basically came back and got an appraisal.
Okay, thank you. No further questions at this time.
All right. Ms. Brett, do you have questions?
No, we don't.
All right. Chairman Sylvie, do you have questions for the witness?
No, good.
All right. Are there any questions from the commissioners? All right, sounds like there are none. I have a question or two, Mr. Flower. When it comes to the ballot language, what role did you have in forming that language?
Well, that's actually a pretty important factor from the city's perspective, because we, like a lot of the language, a lot of the conversations conversation in here has been kind of like between the Public Service Commission and the staff and then the All-American. But one party that's not, I don't feel like it's kind of being left out of the discussion is the city, because no matter what everybody does, the ballot language that we prepared was that the sale price was based on the appraisal, because that was one of the critical things when we went to have it on the ballot. I was requested by the public, they wanted to know if they're gonna get into something. They were concerned that you wouldn't just give the mayor a blank check authority and say, whatever number you come up with, that's what we would agree to sell it for. So the way we prepared that was we came in and said, okay, we waited to do the ballot until we went through that whole appraisal process, had a chance to see it, had a chance to share it with the public, had a chance to do it on that level. So the public in Eureka is relying on the appraisal that was put out there, and then we put as kind of a check on ourselves. That was the key term we put in the ballot language was the $28 million number. So that, in addition to kind of the conversation we've had here about negotiating it, I don't believe I have the authority to, based on our ballot language, to do something else. And the city voters intentionally did that to keep me from, doing something that isn't of value.
But you yourself, what role did you have? Was it you and the Board of Aldermen and
Council.
City Attorney? Yes. Discussed that and came up with that specific language.
Yeah, so it was a mix of legal issues, and it'd be a mix of, political and all the rest. What is the fairest and best way to put that in? So I talked but I was involved with this specific language. The city attorney would probably be the person that physically drafted it, and then it was approved by the board, put on the ballot in that form.
Did you use other cities' ballot language to kind of form your ballot language?
I'm sure it was the basis of it. Our city attorney probably looked at not that attorneys ever do that, but yeah, I'm sure she looked at models and said, okay, this is, I do think the language on dollars was one, though, she had said that was something that was probably the most heavily discussed part of it was good, because again, we had talked about whether that language would go on prior to even having, one of the thoughts early on was, could you attempt to go through that process before you even had an appraisal and authorize the board to pursue the negotiation and enter into that, because that's an option the city had, but they didn't want to do that, or we didn't think it would be possible to get it passed doing that.
So ultimately, the city's council felt that it was important that the actual dollar amount be included in the ballot language.
The city council, I don't know that she would have said, she was providing the language and the options. It was absolutely critical to the board, myself, and to the public, because that was stated, and that was a key term that was discussed over and over again. And I couldn't tell you how many times I referred people to the appraisal, to that process, to the assets, and all those type of things. So I would have never taken the time. I mean, because if you think about it, big picture, I mean, this is the first hearing we're up here, but I started looking at the system in 2019 when I was first elected as the options. It took all the way to probably 2020 to get through negotiation, get on the ballot. We voted on it in 20, where you got, they submitted, we did a final contract at the end of 20 and submitted it in 21. So I mean, this is a 3-year process for us with employees and trying to, the whole time we're doing this, we're maintaining that system. From a city perspective, if you can't rely on the appraisal, it's going to be very difficult. I mean, it's hard to operate and run the system, but not, that was our whole point, was there was no reason to go to the ballot if you don't have a price. There's no reason to get everybody into this kind of state if you can't rely on the purchase price.
Gotcha. So when you were looking at other cities and how they, the language they used in their ballot issues, did they typically include the sales price in the ballot language?
I'd be going off memory, but I think it was an option. She showed us both ways. I believe that she did it was an outside of Missouri. She was looking at a lot of different places, and I think she had seen options either way. It seemed like, from my memory with talking to her, though, as the dollar amounts increased, it became increasingly important, or it was more prominent as you saw it become a more significant issue. There was more information to the public.
All right. Give me just a second here. right, Mr. Williams, do you have follow-up questions?
Just a couple. Mr. Flower, if I understood what you said correctly, you testified that the 28 million in the ballot was based upon the appraisal?
Yes.
And did the city ever consider including in the ballot language a price below which the sale would not occur?
No.
Thank you.
And if I don't, is it okay to add something to that, or is it?
Thank you. You
No.
answered my question.
Okay.
All right. Ms. Bretz, do you have follow-up questions?
No.
Mr. Cooper, would you like to redirect?
Yes, just a couple, Your Honor. Mayor Flower, you were asked several questions about the ballot language there. And I think this is in your testimony, but in your opinion, did you believe that you could execute a sales contract before the completion of that election? Did you believe you had authority to enter into a contract prior to holding the election?
No, there was no authority. The residents had to approve they had to give us authority to enter an agreement.
And Mr. Williams had just asked you about other possibilities for the ballot language, I guess, the ability to go lower than the appraisal. As a mayor, do you believe that you can sell the city's property at something less than its appraised value?
Well, that's, again, sitting here in the hearing, that's been one of the most difficult things for me to try and figure out is that, for instance, again, you guys have a lot of language about book values or not book values or appraisals or different things, but one of the things that happened to me a lot was the residents would always say, you need to make sure, we have these assets, they're proud of the assets, and they want to make sure that they receive fair compensation. But in reviewing all these different things, I mean, given this new situation, this would be asking me to go back, for example, and say, well, because a water tank was contributed in the development and it doesn't have like a book value, it wouldn't have a price. I would have to basically give it to Mo American as opposed to sell it to Mo American from a city standpoint because of the accounting. And those are the exact type of things that the residents didn't want me to have the authority to do, in which I don't feel like I have the authority. I don't see how I have the authority like any other asset to sell things below their appraised value. And there's clear examples of that. So no, I don't think I have. And it would have been a very strange, if you had somebody, I don't know any sale transaction where somebody would authorize you to, do it at the appraised value, but then pick a number, like a safety net number. I don't, and if there was a safety net number, I don't know why you would think that again, somebody would push you right down to the safety net. I don't know how I could come up with all those combinations. So that to me was why the appraisal was so critical, because I thought, well, if we have, 3 appraisers and everybody comes out and looks at the system and we have it and we do all that and we provide all the information, I thought that, in my mind, I thought that was what set the price. I thought that's what this was all about, and if you can't agree on the price, but it sure does seem like this process is gonna have a hard time. This is a lot of, it seems like usually in a negotiated deal, the price is understood pretty early before you get into the details, but I didn't mean to run on.
That's all the questions I have here.
All right. Thank you. All right, Mr. Flower, you may be excused. Thank you for your testimony. All right. Do we need to take a break here? I think we'll take a break.
Are you at, Judge, I'm sorry.
Yes, I am asking.
Suggesting that we will.
Somewhat both. Would you like to take a break?
Sure, it might not hurt.
I suspect that the next witness testimony may be somewhat lengthy. So, yes, let's take a break. We'll go off the record.
For how long?
Let's see. It's quarter after. Let's make it 11:25.
Thank you.
Judge Housekeeping, those DRs, the emails, should I email those to you, or what's the best way to get those two.
I'm trying to figure out how to mute this phone. Oh, there it is. All right, is everyone ready to proceed? All right, let's go back on the record. Mr. Cooper, call your next witness.
Thank you, Your Honor. We would call Mr. Joseph Bates. And Mr. Bates is on the WebEx.
All right. Mr. Bates, I thought I had the ability to unmute you, but it doesn't look like that I do. So could you unmute your WebEx connection? Thank you.
You're welcome, Your Honor.
All right. And you are Joseph Bates?
I am, sir.
All right. Would you raise your right hand to be sworn in, please? Do you solemnly swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you.
You're welcome.
Go ahead, Mr.
Mr. Bates, this is Dean Cooper. For a moment there, your camera came on and then it went back off again. Can you see if you're able to start that on your end?
Dean, I see him.
Yeah, I don't control that. I have the video turned on and I can see myself in the camera.
Gotcha. It just may have been the view that I had in the hearing room, so I apologize. Sir, would you state your name?
Joseph Bates, B-A-T-I-S.
And by whom are you employed in what capacity?
I am employed by Edward J. Bates and Associates Incorporated, which is a real estate appraisal and consulting firm. And I also own a company called Utility Valuation Experts. I'm the president of both corporations.
Have you prepared, for purposes of this proceeding, certain direct and surrebuttal testimony in question and answer form?
Yes, I have.
Is it your understanding that that testimony has been marked as Exhibits 3 and 4 for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
No, sir.
If I were to ask you the questions which are contained in Exhibits 3 and 4 today, would your answers be the same?
Yes, sir.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would offer Exhibits 3 and 4 into evidence and tender the witness for cross-examination.
All right, are there any objections to those coming into evidence?
Judge, we do object to the admittance into evidence of the valuation report, which I believe is attached to his direct testimony, Exhibit 3.
And what's the basis of your objection?
There's a few objections. Basically, we have a foundational type objection to it. According to the appraisal, 3 appraisers were involved in producing this report. The Missouri American has only made one of the appraisers available to testify. Mr. Bates cannot testify to pieces of the appraisal that he didn't himself, he wasn't involved himself in preparing. And we won't have the opportunity to cross-examine those other appraisers also. We also question the legality of the appraisal. It's not clear whether all the appraisers actually visited the site. According to the standard rules, the appraisers are to sign a certification, and that certification includes a statement whether or not they actually visited the site. And based on the emails, we can't determine whether they all actually did visit the site. The appraisers are also supposed to, as part of the certification, they're to state whether other people were involved in assisting them in producing the appraisal. It appears that there are actually 4 appraisers involved in producing this appraisal. And this 4th appraiser is not mentioned in the appraisal. And of course, he's not available here to testify. That's our objection, Judge.
All right. I'm going to overrule your objection and admit Exhibits 3 and 4. All right. Mr. Williams, do you have questions for the witness?
Thank you, Judge. Mr. Batis, did you request Kelly Simpson to prepare an engineering report regarding the Eureka water and sewer systems?
Yes, sir, I did on behalf of the 3 appraisers that were selected for the assignment.
In her direct testimony, Ms. Simpson says, and it does not identify who, that she became aware of GIS data that was relevant to that engineering report. Do you have any knowledge of how she became aware of that GIS data?
I don't know specifically how she became aware of it. I do know that the typical process that we're involved with involves communication, discussions amongst the appraisers and the engineer.
I think you've already answered the question. You said you don't know. Did you not?
I don't know specifically for that assignment if how she did. No.
So you didn't bring it to her attention?
I may have.
What, if you did, what would have caused you to bring it to her attention?
Typically in this process, because we are involved in appraisal assignments in different states and in different counties, there are discussions amongst the participants as far as their understanding and knowledge of the existence of different data sources, including GIS data. And it is not uncommon during an inspection or during a phone call or during a meeting that one or more of the appraisers or the engineer or someone from the representing the seller, the local municipal body, might mention, for instance, the existence of GIS data or tax assessor data or different sources.
Excuse me, sir, but I don't think you're answering my question, because I'm asking why you would have informed or your basis, and what I'm hearing is a lot of hypothetical circumstances. I mean, did someone make you aware of it?
Again, I can't recall specifically what those discussions were on site, but I'll just try and explain the process, that those are the types of issues that come up during that, during those meetings and consultations where we talk about data sources, but I don't keep track of exactly who mentioned what data sources. I'm sorry.
So let me ask it this way. Did you see an initial report and then respond back to Ms. Simpson, hey, did you look at for GIS data?
No, I did not, sir.
Thank you. No further questions at this time.
All right, Ms. Bretz, do you have questions?
Yes, thank you. Good morning, Mr. Bates.
Good morning.
Before we get started, perhaps we could establish that you have the email. It's hopefully Mr. Cooper has sent those to you. We've marked it as staff exhibit 108. Do you have that before you?
I don't think he does. Well, perhaps he does.
I don't recall seeing that, no.
What's the DR number that you're referring to?
61.
61. Mr. Bates, it's possible that DR 61 response went to you maybe yesterday, late afternoon, early evening, probably from me, I'm told.
Okay.
Although I'll have to look to be sure. At 4:13, I'm told by Mr. LeGrand.
Dean, this is Nathan.
Yes, sir.
I believe you got an email from, I believe, Karen, but at least this morning, that includes those exhibits. I don't know if you could forward those perhaps?
Yeah, let me look here.
If it helps, my email inbox shows it arriving at 11:25 this morning.
Yeah, for some reason I haven't, my inbox hasn't updated since 9:38. Hold on just a moment. I think I've got to reconnect to the Wi-Fi.
I'm seeing if our staff can forward those exhibits to him.
I found it.
Yeah. You have those now, Mr. Bates?
Yes, sir.
Okay.
Should I proceed, Judge? Or,
Yeah, you may proceed.
and then one other thing, Mr. Bates, I assume you have a copy of your evaluation report in front of you?
Yes, I did.
Okay, great. In the early stages of preparing your report, did you receive documents from Missouri American about the Eureka system?
I'm sure we did. Back when we start, that's customary, and I believe we did in this case as well.
Did you have a particular contact person at Missouri American that helped you to get documents and relay communications?
There's a few people that I may have been dealing with in this case, but I believe the primary one would have been a lady by the name of Nikki Pacific.
What was motion. Okay.
Is that correct, Mr. Bates?
Yes, it is.
EAC IFIC.
TACIFIC. First name Nikki, Nikki.
All right, thank you.
You're welcome.
Was one of your contact people also a lady named Melisha Phillips?
I've dealt with militia before, and again, I don't recall specifically if it was in the Eureka case, but it wouldn't surprise me if it was.
Do you know what Ms. Phillips' position is at Missouri American?
I don't recall her title, no.
Do you recall exchanging emails in October of 2019 with Ms. Phillips about getting these documents?
I don't recall specifically, but again, it wouldn't surprise me that there were emails back and forth. And the document that I just opened up appears to represent the same.
Do you recall discussions about 50 pounds of documents from the city of Eureka regarding the Eureka system?
I'm sorry, could you please repeat that? It faded out at the end.
Sure. Do you remember 50 pounds of documents from the city of Eureka about the water and sewer systems? Discussions about 50 pounds of documents?
I don't recall that specific reference to 50 pounds. No, I don't recall that as I sit here today, that specific reference.
If you could please turn to page 123 of that string of emails, and the numbers are in the top right-hand corner.
Ms. Bretz, which exhibit number?
Oh, I'm sorry, it's exhibit 108. About the middle of the page, there's an email from Ms. Phillips to you saying, I believe he wants to deliver the actual documents. As he said, there are about 50 pounds of documents. He's going to reach out to you as well. If I said that the he, there is Mr. Sabo, the administrator, the city administrator of the city of Eureka. Does that sound right?
Yes, that's reasonable. Would have been Mr. Sabo.
And then above that email, you responded back, sounds good. Is that correct?
Yes.
So from this, it sounds like you received 50 pounds of documents about the Eureka system.
I don't recall specifically if they were ever received and how many pounds there were, or what format they came in. It's possible documents were shipped to us.
Do you recall receiving documents from Missouri American about whether the systems meet Missouri DNR regulatory requirements?
I don't recall specifically, no.
You don't remember receiving any documents about that?
As I sit here today, I don't recall what was in the 50 pounds of documents if they were received by me. I don't recall specifically, no.
Do you recall any documents from Missouri American about DNR?
Not as I sit here today. I don't recall what documents were received by us, no.
So it sounds like possibly there was a lot of paper documents. Did you also use a shared drive to share documents with Missouri American?
Generally speaking, that's a common way that documents were shared. I don't recall specifically in the Eureka case if a shared folder was used, but again, it wouldn't surprise me.
If you could please turn to page 115 of Exhibit 108. At the top of the page, and it's the actual email, I guess, starts at the bottom of page 114. But it's the email from you to Ms. Phillips, and you write, yes, I just downloaded all of the files and put them in a Google Drive folder, which I shared with it to appraisers and the engineer. During the course of the project, we will be using the Google Drive folder to download our photographs and drafts of our report sections. Did you see that?
Yes, I do.
Do you recall any other documents besides photographs and draft report sections being put on the Google Drive?
Again, I don't recall specifically, but by looking at this email, I probably would have shared whatever documents I had received. That was the typical protocol.
And it sounds like as you were drafting the sections of your report, the documents were put onto the shared drive. Is that right?
I think that that's partially true. The shared drive is used for not just drafts of parts of the report, but different information that appraisers might be sharing or discussing whether or not it makes it into the report.
So also included on the Google Drive is your impressions and your discussions and your comments with the other appraisers?
I don't necessarily think there were our discussions and comments were on the Google Drive. I think to clarify, if the appraisers were having a discussion, for instance, about a particular sale or the location of a lift station, we might use the shared drive in those instances to share exhibits, plats, notes, various information, helping each other solve whatever questions or issues we're dealing with during the process of developing the appraisal report.
Okay, that gives me a better idea. It sounds like the use of the shared drive was pretty expansive. Is that accurate? In other words, let me rephrase the question. In other words, you put a lot of documents and information onto the shared drive.
Again, I don't recall specifically in the Eureka case going back two to almost 3 years or 2.5 years, how expansive the use of it was and what how voluminous the documents were. I'm just talking in a general sense. That's the process we would follow, and we would use very often a shared folder or shared drive when necessary, appropriate to share data. And it very well may have been the case here, as it seemingly was in Eureka case. How extensive, I can't recall.
Do you recall who had access to that shared drive?
I can't with 100% certainty tell you, but I can give you my best guess based upon our typical procedures, if you would like.
Okay.
It would be the other appraisers participating in the assignment, which in this case were Mr. Deenan and Ms. Goodman-Schneider. And depending upon the contents of the folder, typically the engineering firm, which in this case would have been Flynn Engineering. Very often we would include a representative from the company, in this case, American Water. So it could be any number of those, but most likely that's the small group that would have been invited.
Okay. Looking at the email right below the email we discussed at the top of page 115, you see, good morning, Joe. Yes, we were all set. If you need anything, please let me know. Also, were you able to access the files? Thanks, Ms. Phillips. Do you see that?
I'm sorry, what page of the exhibit is that on, please?
115, we're on the same page there.
Yes, I can see that from Melissa Billups.
So that indicates that Ms. Phillips had access to your, or to the shared drive, right?
Mhm. I don't recall, but by looking at this, I can't conclude from her message if she's saying she has access. She's saying we are all set. I'm not sure if she's confirming access or not.
But based on what you said earlier, at least somebody from Missouri American had access to that shared drive.
I don't know with certainty. I think, again, our typical process would be to include anybody that we thought would be participating in providing documents or need to see documents. And in many cases, a representative of the company would be involved. But again, I don't know with certainty in this case if Militia or someone else from American Water was in that circle, if you will.
So did Missouri American have access to your draft appraisal sections as you were drafting them?
Typically, no. That's draft appraisal or sections of drafts, if you will, because of this process with 3 appraisers participating, are typically shared between the 3 appraisers as it pertains to the analysis or conclusions. However, it is not uncommon for us to share with, in some cases, either American Water or one of the clients or the selling community, sections of the report that deal with property characteristics that we might want them to be aware of, such as assumptions regarding the split of parcels into or division of properties, assumptions regarding easements, ownership rights. So sometimes they'll see sections or parts of it, but we do not share with anyone other than the 3 appraisers any part of the actual opinion analysis or final conclusion or the market data that we're using.
Did Missouri American personnel review drafts of your report before the finished product?
I'm sorry, one more time, please.
Did Missouri American personnel review drafts of your report before you had the final report?
I don't believe so, and I don't recall, but again, there's occasions where a draft is sent to a client if there's an issue again with the assets and how we're describing different land rights or issues with easements and parcel splits. So it's not uncommon that a draft will go out and we will ask the client, please pay attention to a particular section and see if this is the correct interpretation or correct understanding of what's being conveyed. And sometimes that draft might have a value. It might be the full report ready for signatures, or it might just be part of it. It's a very fluid and changing process, case to case, depending upon the flow of information and what's available.
Do you recall sending emails to the other appraisers and Ms. Billups, inviting them to make changes and corrections to the report?
I don't recall, but that's typically what I would do as I'm putting together the final report, is to ask them to, so we could all check each other's work. So that's probably reasonable if that was done in this case.
Could you please look at page 25 of Exhibit 108?
Yes, I'm looking at it.
You're there?
Yes.
Okay. And that's an email from you to the other appraisers and Ms. Billups, correct?
That is correct, January 12th.
And the email is, "Hi all. While reviewing the report this morning, I made several changes/corrections. Use this copy for your review. Please send your changes/comments. Thank you, Joe."
Correct.
So what parts of the report would you have asked them to review?
Well, for instance, when we're putting together the area analysis, that might be a combination of the work product of 2 or 3 of the appraisers, not always just one. So, for instance, if Mr. Dinan's office was putting together that, and I supplemented it with some graphs or demographic data, for instance, I would send that out and hope that he would review that to see that if I'm using the data in the right context relative to that particular area and whether it is a fair representation of the market. Likewise, Ms. Schneider, Goodman Schneider, for instance, might be working on the comparable sales section and assembling our final tables and charts. And once I receive those and input those into the report or the draft, I would send them out just to get extra eyes to look at the math, to look at the reference to sales numbers, to recheck the math. And in many cases, for instance, Mr. Dinan's office would come back and say, at comparable 3, when I looked at the unit price, it was off by $20 a customer or something, math error, we need to correct that or change that. So really what I'm doing at this point is asking everyone to give a final review, since we are all signing the report, we are all responsible for its contents, to make sure that we're all comfortable with all of the final changes, insertions, and to make any corrections that are appropriate.
Do you recall Ms. Billups giving you input into the report before it was final?
No, Miss Billups is typically not involved in that part of it. The only thing that she would give feedback on is if she noticed that the assets that we described, for instance, maybe we described a 10-acre piece that had 3 buildings on it, and she might clarify that not all buildings were included in the transaction, or that they were splitting the property. So her input was more limited to those types of issues, and typically at this point of the assignment, there wasn't much feedback from her because those issues would have been already resolved.
Could you please turn to page 92 of the email? And again, this is the email from you to Ms. Billups, is that correct?
I'm just getting that one moment, please. Yes.
And the email this is from January 17th, 2020.
That's correct.
Good morning, Militia. I received from Kelly last night the numbers for Eureka I'd like to discuss. Please call me at your earliest convenience. Thank you, Joe. That's what the email says, right?
Yes, it does.
So from this, it sounds like you were actually discussing substantive numbers with Ms. Billups. Is that your interpretation?
Yes.
Do you remember what numbers you were discussing with her?
I don't recall, but the presumption is whatever numbers were reported by Ms. Simpson.
So you were taking Ms. Simpson's numbers, and Ms. Simpson is the professional engineer from Flynn, right?
Correct.
So you took Ms. Simpson's numbers, and then you wanted to discuss those with Ms. Billups?
Yes, it's basically a status or update of where we are, that we're receiving information and giving her the update of the progress.
That sounds more substantive than double checking the accuracy of buildings or other similar data, doesn't it? It sounds like you were actually discussing the appraisal numbers.
Well, no, I think that's misleading. First of all, the context of these emails is completely different. The first email, or the previous email we were discussing, was draft reports that were going out, and my comments regarding feedback, typical feedback from Ms. Billups about buildings and land size, is in the context of clarification and accuracy of the draft report. This email clearly is in a different context. This is an email that is subsequent to me receiving from Ms. Simpson the numbers and her work product, and I was sharing those, not the appraisal analysis and not any value conclusions, but sharing the numbers that were arrived at by Ms. Simpson that we would later be using in our report, and that ultimately Ms. Billups would have access to anyway, as they would be attached to our appraisal report. But this certainly is not a discussion of the appraisal opinions or appraisal valuation process.
Okay. What parts of the appraisal report did you prepare?
Well, typically, and I believe in the case of Eureka, I'm responsible for assembling all the sections and putting the report together, more or less formatting it and assembling it. I also work on, we divide up the responsibilities amongst the three of us. I typically am responsible for, as I believe I was in Eureka, land valuation or land descriptions, identifying all the sites, all of the fee holdings, all of the easements, all of the locations of the various components and assets. I work on neighborhood and area descriptions and data. I work a lot on the what I'll call the report template, all of the use PAP requirements such as explanations, definitions, standard requirements that are mandated by Missouri law and by use PAP. And then I also participate in, with the other appraisers, the selection of comparable sales, the analysis and discussion and conferencing regarding the relevance of the different sales, which ones to use, which ones to exclude. And likewise with the appraiser who would be responsible for collecting land sale data, we would have discussions about comparability and highest and best use issues and the assemblage of that data that would be relied on by all of us in the report. So it's, again, it's three sets of hands in there all doing different things and sometimes carrying over into each other's responsibilities, but that's just the nature of these assignments.
And what part did Mr. Dinan prepare?
Diane, again, was involved with various components with myself and Ms. Goodman-Schneider, but one of his primary responsibilities was to collect market data pertaining to land values in order to allow us to develop opinions of the fee values and easement contributions for the project. So his firm would be responsible for that research. His firm also would be responsible for compilation of the contributory values of all improvements in the cost approach, meaning buildings, fencing, structures, where they would cost them out and depreciate them, measure them, obviously, describe them. His firm was also instrumental in describing the property, the different components. And then he lastly contributed to the market analysis and descriptions of the area and the overall general descriptions of the property and its location.
And what parts of the report did Ms. Goodman-Schneider prepare?
Ms. Goodman-Schneider, again, consulted with us in various parts and would help with the descriptions of the buildings or the properties as needed, or maybe clarify some issues that, questions we would have had, maybe she remembered. But her primary responsibility would have been, in this case, to take the comparable sales that were being utilized for the report or relied on for the analysis, and assembling them, analyzing them, providing the statistical information, the tabular or exhibits with the data and tables, and all the descriptions of the data for us, the market data.
Thank you.
You're welcome.
You inspected the systems on December 10th, 2019, right?
I believe so.
Did anyone go with you on that inspection?
I don't recall. I think actually I may have inspected this one twice, and I don't recall if which inspection I was with a group or which inspection I was by myself. I know we had some difficulty with one of the inspections because of the weather, and either it was postponed or not the whole group was there, but I don't recall specifically who was there.
If you turn to page 1 of your appraisal, and there's some introductory type information there.
Page 1 being the summary of salient facts.
Yes, you're there.
I'm there.
So it says about halfway down, date of inspection, December 10th, 2019, Mr. Dinan, Ms. Goodman Schneider, and yourself, right? We're inspecting
Right.
it.
Right. So we were all there on the 10th. It was the subsequent date that I was alone.
And that's the March 18th date?
Correct.
Could you please turn to page 98 of Exhibit 108?
Back to the emails. Page 98.
Yes.
Yes.
So towards the bottom of that page, there's an email from you to Mr. Dinan, Ms. Simpson, and Ms. Phillips. It's dated December 10th, is that correct?
Yes.
December 10th, 2019.
Yes.
And that was the date that you said that you, Mr. Dinan, and Ms. Goodman Schneider were inspecting the property, right?
Yes.
And that email says, hello, Ed and Kelly. I would like to set a date with Craig Sabo for the two of you to inspect the Eureka facilities. It seems like all of our information is in place and in order now, so things should go smoothly. Please provide me a list of the dates that you are available over the next 7 to 10 days so I can check with Craig and get this scheduled and keep it moving forward. A prompt reply would be helpful. Thank you again, Joe. That's what that email says, right?
It does.
So if all of you were looking at the property on December 10th, why would you send an email to Mr. Dinan to set up a inspection of the property?
Because I believe, again, I don't recall all the details, but I recall that on the inspection date, which I believe was December 10th, there was some problem, if you will, with the coordination of either seeing all the properties or maybe the information that we requested, different exhibits and maps and foundation material wasn't available. And I believe at that time, we had decided that it wasn't real efficient to continue and we were going to reschedule and come back another time. So I if I'm not mistaken, this email is addressing that matter, that we need to schedule an appointment fairly soon and get back down. to the property.
I guess I still don't understand. So you're saying that the three of you inspected the property, but then you also sent an email to set up another inspection?
Well, I think what happened, and maybe the report is poorly written, but I think what happened was we were there to inspect and maybe either started the inspection or didn't have access to everything we needed or all the information. And it just wasn't in the best interest or efficient to continue, and we decided to come back. I think it was more of a rescheduling, if you will, to complete or re-inspect.
So the three of you went down to Eureka and things weren't going smoothly. And then you sent an email at 9:35 that morning to Mr. Dinan to schedule another inspection.
Again, I think those are the circumstances. I don't recall it, but I remember something like that, those circumstances taking place where there was a scheduling conflict or an inspection that we couldn't complete. So that very well may have been played out.
But you recall the three of you going down there on December 10th, 2019?
I believe so, unless again, my report and the three of us misrepresented the date or made a mistake. But I believe December 10th was our first inspection there. Whether or not we inspected all the facilities is a different issue, but I do believe we met there December 10th.
But you weren't able to complete the inspection?
Again, to the best of my recollection, I would say reading these emails and trying to recall the chain of events that no, there was some problem or some issue with trying to see all the properties. It may have been a personnel issue, a timing issue. It may have been documentation and data that we needed. But for whatever reason, I believe we had to re-inspect or come back on a second occasion.
Okay, I think I better understand that now. So then this email generated the inspection that was planned for December 17th, right?
Apparently.
And then that inspection was canceled because of bad weather, correct?
I believe so.
I'm sorry, I didn't hear you.
I believe so.
Was the canceled inspection rescheduled so Mr. Dinan and Ms. Goodman-Schneider could inspect the property?
I believe so. My best recollection is that it was rescheduled and we were all present.
Can you show me where in your report or in the email that's discussed?
I'm sorry, could you repeat that, please?
Could you please show me in your report or in the emails where Mr. Dinan and Ms. Goodman-Schneider made the inspection?
Probably the only reference to that would be on page 1 of the report where the names and the dates are listed. I don't know if there's any other section of the report that addresses what date or dates any of the parties inspected the property. It's not uncommon that multiple inspections are made, so my best guess is that we were all there on December 10th and they either came back or we came back on another date.
But you don't recall what that later date was?
No, not 2 years later. I'm sorry, I don't.
Okay. Was there a rush to get the appraisal done by the end of 2019?
Now, rush is a relative term. I've been doing appraisal work for 38 years, and I can't think of too many assignments that weren't a rush. I think in the context of this type of assignment, a rush job would be anything, within a month or 6 weeks. That would be what I call a desirable turnaround time. And I think typically we're able to do that and provide that type of service, depending upon a number of factors, including the availability of information, the completion of the engineering report, what type and how available access to the property is, as well as access to any municipal representatives that we might have to follow up with questions to. So, well, we never guarantee a client that we will have it done by a certain date. The typical expectation is about 6 weeks, and that's considered quick turnaround, whether you want to characterize it as a rush. But that's a typical turnaround time, 6 weeks, maybe 8 most.
Okay. There was some discussion in mid-December after the inspection was canceled about a Plan B. Do you recall that?
I don't recall that specific reference.
This is on page 35 of those emails. About middle of the page, there's an email on December 16th from Ms. Simpson to you. Joe, we are getting some nasty weather here. Can we just discuss Plan B to get the Eureka report done? Is the end of the year deadline an absolute deadline? Do you see that?
I do see that.
What was Plan B?
Well, that email is from Kelly, correct? No, I'm sorry. Who's that email from?
Ms. Simpson?
Ms.
Clint
Simpson. I'm sorry, Ms. Simpson. Yeah, I don't know that. I know with certainty there was no Plan A, Plan B per se. I think that's just I can only speculate what she meant, but I believe it's a reference to maybe an alternate plan or another date because of weather, a Plan B, but not necessarily some laid out, identified plan or sequence. Just more or less an alternate date or alternate option. And then I believe it had to do with scheduling, I guess is all I could say, or all I could speculate.
Okay. A fellow named Jordan Liner is included in many emails. Who's he?
Jordan is one of the associates of Mr. Dinan, and he is one of our contacts at the Dinan office for helping to assemble information and do research for us for our appraisal assignments.
And he's a certified appraiser like yourself?
You know, I'm not sure of Mr. Mr. Liner's qualifications. I know he's a longtime employee who with the Dinan firm, and I've met him over the years doing work with them, but I don't know his professional qualifications.
What was his participation in the report?
Helping measure buildings, taking pictures, collecting information for Mr. Dinan. Sometimes Mr. Dinan would have up to 3 people attend from his office, and they would presumably just help him collect and gather information.
Is there any particular reason why he wasn't listed as in your report that's giving you assistance?
Yes,
There is a reason?
yes.
Why is that?
USPAP and the Appraisal Institute only require the identification of appraisers or non-appraisers that that have a significant contribution to the analysis and final opinion. Both USPAP and the Appraisal Institute bylaws and supplemental standards recognize that during the course of an assignment, particularly one like this, there are potentially many people that are helping with different aspects of the assignment, collecting information, verifying information, putting together plat maps, aerial photographs, zoning information, etc. And for those that are performing those functions as part of the process, and those steps not being considered substantial to the analysis, it's not necessary to list them. So the policy is, the general policy with appraisers is you don't list those people. You're only required to, and you typically only identify those that contribute to the analysis itself.
Okay. You stated that you prepared some of the comparables for the Eureka water system.
Involved in the process, yes, and selecting some and excluding others.
So were you involved in assigning a unit value of $4,500 for the water customers?
Well, that's more a function of the primary appraiser who's in charge of that responsibility, and then that's discussed and analyzed and explained, and then we either concur or talk about changing it. So in this particular assignment, Ms. Goodman Schneider was writing up the sales and presenting them in the report format, style, and tables and exhibits. And after she completed that, then yes, as part of the discussion and review of the information, I was involved in the reconciliation of the final opinion in the unit values.
Did you discuss, or in preparing your report, did you consider issues that the water system has with DNR?
I believe I can say with certainty, we would have considered whatever information was available to us, primarily through the Flynn report, but I don't recall specifically what DNR issues were weighed and considered on that assignment back then, but typically, yes, we would consider whatever we were aware of and it was brought to our attention.
But you didn't discuss DNR issues in your report, right?
Not specifically, no. Maybe unless there was a reference to Ms. Simpson's report and they were discussed there, but that would not be something that we typically would include in our appraisal report, no.
Is that because you took Ms. Simpson's information and then, let me rephrase that, you weren't involved in finding out whether the systems were meeting regulatory requirements, correct?
And when you ask, when you say you, I'm presuming you mean me and the other appraisers, the three of us putting our report together? That is correct. That wouldn't fall under something that we would typically do.
Okay, thank you. I have nothing else. Oh, for housekeeping, I would ask to admit Exhibit 108, Staff Exhibit 108 into evidence.
All right. Are there any objections? Exhibit 108 is admitted. All right, we'll go to questions from the bench. Commissioner Selby, do you have questions? All right. Are there any questions from the other commissioners? All right. All right, Mr. Bates, I do have some questions. I'd like to ask about your experience specifically when it comes to appraisals of utilities. How many utility appraisals have you performed?
And Your Honor, by utility, you mean water and sewer exclusively?
Yes, yeah, let's stick to water and sewer since that's what's most.
They make up the majority. Water and sewer systems make up the majority of the utility systems I participate in at evaluation assignments. I would say over the last 10 to 15 years, I've probably been involved either solely, exclusively, or participated with others in assignments for about 50 to 75 systems in 5 or 6 different states.
How many of those, if you can recall, how many were water systems? How many were wastewater systems? How many were combined purchases of both wastewater and water systems?
I would say that it would be pretty close to a third of each. In some cases, for instance, there's a community in southern Illinois where one assignment was the water system, and then one assignment a year or two later was the sewer, so that would be 2 separate, even though we ended up doing both of them. But I would say for a particular assignment, probably about a third were just water, a third were just wastewater, and approximately a third would have been acquisitions of combined systems.
Of those roughly 50 to 75 appraisals that you've done, how many of those were in Missouri?
Probably 15 to 20.
How many were for American Water Company and its affiliates?
Maybe half, 2/3. I'm sorry, are you talking about the Missouri or all?
All, any of the affiliates of American Water Company.
Right, I'm sorry, but are you talking about what percentage of all of the assignments or what percentage of the Missouri assignments?
All of the assignments.
Of all the assignments? Probably about a quarter to a third would be one of the American water companies, I believe.
And then I will go ahead and follow up. How many of those were for Missouri American Water?
Of that approximate quarter or third, I would say probably half Missouri, because I do about an equal number in Illinois for American Water.
Okay. And so for Missouri American Water, what kind of numbers are we talking about as far as number of appraisals?
I don't know, 10 to 15 maybe. I'm not sure if the math works out, but I'm just giving you my best guess off the cuff. I'd say maybe a dozen in Missouri for American.
And that would be in that roughly 10 to 15 years.
Well, I've been my experience goes back between 10 to 15 years. My experience in Missouri goes back about 7 or 8 years, I believe. So yes, they would fall within the last 7 to 8 years.
Yeah. As far as this particular appraisal, have you ever worked with Mr. Dinan on other appraisals?
Outside of Eureka or outside of utility assignments altogether?
Outside of Eureka?
Oh, yes, certainly I have. He's been involved in several of the assignments that I participated in Missouri for American Water.
How about Ms. Goodman Schneider?
The same, sir.
Okay. If I could, kind of direct your attention to page 6 of your report, which is marked here for the hearing as Exhibit 3, your direct testimony, Schedule JEB-2, which I believe is marked page 11 of 98.
Yes.
And so you have a definition of market value. Does market value consider the condition of the assets? And if so, how?
Very good question, because it absolutely does. And I think implicit in a market value opinion, not I think, I'm 100% certain, that implicit in an opinion of market value are all aspects of property, including financial, economic, physical, locational, time or market conditions. Now, understanding that although those are factors and influences to value, the degree of and the extent of information we always have with respect to all those elements and how we're able to analyze them varies from assignment to assignment. In a perfect world and in a perfect appraisal assignment, which I've yet to see, we have all the information necessary about the market, the financial components. We have perfect sales data. We know everything about the property physically, economically. So we try to take into account all aspects of the property, but clearly the extent of information we have varies from property to property and assignment to assignment, but it is a factor that's considered, just as it's a factor in the comparable sales data that we rely on.
Okay. On page 5 of your direct testimony, on line 14, you make reference to a January 20th, 2020 appraisal report. Was that appraisal report, has that appraisal report been made available to the commission?
I do not know, sir. I don't know what was submitted.
But you are familiar with an appraisal report dated January 20th?
I am.
Okay. if I could draw your attention to your cover letter with the evaluation report, letter dated March 23rd, 2020. It is scheduled JEB-2, page 2 of 98.
I'm there, sir.
Okay. The footnote at the bottom of the page, I believe roughly halfway down the paragraph, it refers to the engineer's report for an assessment of the water and wastewater systems. Is there any standard for the level of assessment to be performed as part of an appraisal?
It varies. That's a scope of work issue as identified by USPAP that varies from assignment to assignment. So there's no etched in stone standard, but there are guidelines per USPAP that that help guide the appraiser in understanding what they should be relying on and how they should be relying on that type of data.
I've got a couple of questions about the December 10th, 2019 site visit.
Yes.
Was Ms. Simpson there that day?
I don't recall. My recollection is no, but I can't tell you with certainty.
Okay. And correct me if I'm wrong, and it's very possible that I'm wrong, but I believe you testified earlier that on that December 10th, the site visit was brief. And I'm sure that's not the word you used, but for whatever reasons, that site visit did not last very long. Am I correct about that?
That's my best recollection, sir. Yes.
Is it, if I go back to the emails, Exhibit 108, on page 98 of that exhibit,
I'm sorry, what page? 98?
98.
Okay.
I actually have to get there myself, so bear with me. At the bottom of that page, your email is dated December 10th, 9:35 a.m. So
Correct.
does that, should we infer from that by 9:35 a.m. you were making plans for this other visit and were no longer at the site?
I'm not sure if I was still there and emailing or if I was, if the time I'd spent there was completed. But clearly, as I read that email, yeah, there was some effort to get an alternate date set for Mr. Dinan and Ms. Simpson. So I'm assuming they did not make that date, the 10th.
Okay.
We're trying to reschedule. It could have been a weather issue or, frankly, I don't know. I don't recall.
All right. The Flynn Engineering report. It states that they did not participate in a site visit, but they relied on photos from a site visit. Were those photos, if you know, from December 10th, 2019, or from another date around that time?
My best guess, sir, is that they would have been from one of those 2 or 3 inspection dates from the appraisers, that whatever photographs were taken during our customary inspection and uploaded to the Google Drive or shared folder. But that's what Ms. Simpson is referring to, and I don't recall what date they were taken or by whom.
Did those photos become part of the appraisal?
Certainly part of the appraisal process and the development of the opinion, but not necessarily in the appraisal report itself, no.
Would it be possible for the commission to get copies of those photos?
I'll be happy to check, see where they are or find them, track them down and get them to you if they're available, by all means. Or I'll get them to Mr. Cooper, certainly.
Okay, on page 10 of your report, that would be Exhibit 3, page 15 of 98, I believe.
Yes, sir.
It states, also required by Missouri statute pertaining to the evaluation is the inclusion of a professional engineer's report addressing the depreciated cost estimates for the components and infrastructure related to the water delivery and wastewater system. Can you point the commission to the Missouri statutory language that requires the inclusion of a professional engineer's report pertaining to the valuation?
Actually, I don't think it's explicit in the law, sir. I think that's not accurate and poorly worded. It's customary part of our assignment because per use PIP, we typically rely on an engineering report, but I don't think that the statute is explicit.
Okay. Later on in that same paragraph, it states, based upon our reviews and independent research, we find the report prepared by Flynn Engineering to be thorough, prepared in compliance with industry standards, and credible. What is meant by industry standards when it comes to that sentence?
Well, part of the typical engineering report deals with adjustments that are made or factors that are applied to cost estimates, indexing, if you will. Depending upon the assignment, could be indexing original cost forward or a reverse indexing of estimating the current cost of an item and doing a reverse index process to come up with an original cost. And there are various methods or procedures in order to accomplish that. And typically engineers use one of the resources out there. I believe the commonly used one by Flynn is the Handy-Whitman Index, which is an industry index that provides data going back over 100 years for the cost and labor, the materials and labor for construction in different aspects and submarkets. My office maintains a database of 5 different indexes: Handy-Whitman, Marshall Valuation, CPI indexes, and a couple other. And what I typically do when I receive an engineer's report that involves any type of indexing and cost data or original cost data, I look at my own database with the blending of rates and that I maintain through subscription services to see to check on essentially accuracy, and if maybe I don't have the index they're using, to see if the cost figures that they use are consistent with other industry models. So it's just kind of an internal check, if you will, into the numbers that are being used and represented in the report by the engineer.
And then at the bottom of that paragraph, it says our reliance on the Flynn report, it says inconsistent. I believe it's meant to state is consistent with the Appraisal Institute's guide note 4. What is that? Well, first of all, what are the Appraisal Institute's guide notes?
First of all, that's a perfect example of even 4 sets of eyes sometimes don't catch those mistakes. But the Appraisal Institute, first of all, is a private appraisal organization, recognized as the world leader in education, training, resources, and they confer upon its members different designations, the highest being the MAI, which Mr. Dinan and I both hold. And as part of the Appraisal Institute's
Sorry. Could you repeat that?
Sure.
The
Back from the beginning?
no, training resources, and they confer upon.
They confer upon members who have qualified and met the requirements different levels of designations. The highest being the MAI, which is a designation held by me and Mr. Dinan. And as part of its professional standards and requirements for its members, the Appraisal Institute has supplemental standards that exceed the minimum requirements of USPAP. So there's standards that apply for myself, if you will, that are above and beyond the minimum requirements of USPAP. And those are called supplemental standards. As part of the Appraisal Institute's supplemental professional standards, they also offer input into various issues and circumstances that we might find ourselves involved with, such as a situation where we rely on information or professional reports prepared by others, and at varying levels and degrees, of course, could be incorporating those contents of those reports or those opinions into our analysis, into our research. And Guide Note 4 from the Appraisal Institute specifically addresses the issue of when an appraiser, a designated member of the Institute, is going to use or adopt or rely on the work of another professional who's not an appraiser, under what circumstances and rules and would it be appropriate to do so? And Guide Note 4 sets forth those requirements. For instance, are we familiar with the person who prepared the report? Are we familiar with their qualifications and background? Do we have any reason to believe that their work is not untruthful or with bias or lacks objectivity? does the work, as far as we know, although not being experts in their respective fields, does it seem to meet or comport to their professional standards as compared to other reports maybe that we've seen or used or relied on? So there's a series of tests, if you will, or standards that are used as a guide for us before we just rubber stamp and use somebody's opinion or somebody else's work product.
Okay, thank you.
You're welcome.
If I can refer you to page 12. And
Yes.
if you could you take a look at that last paragraph?
Yes, sir.
The last sentence states, however, the 3 professional real estate appraisers co-signing the attached appraisal report assume that the water delivery and wastewater systems components, including the plant pumps and all related facilities, are in proper working order and have been maintained adequately to meet all pertinent codes and regulatory requirements. Given that statement, can you confirm if the maintenance records were reviewed as part of the overall appraisal process?
Again, I don't recall if maintenance records were completely reviewed by any or all of the 3 appraisers.
Did you review environmental regulatory compliance records to determine if the assets had been adequately maintained to meet applicable code and regulatory requirements?
No, sir.
If I could direct you to page 37 of your report.
Yes, sir.
The cost approach is described, and in the 3rd paragraph, it references the different types of depreciation properties experience and lists them as physical depreciation, functional obsolescence, and external obsolescence. Can you explain physical depreciation and give us an example?
Yes. Physical depreciation is if you will, when I teach this course and this material to appraisers entering the field, we simply explain or describe it as the wear and tear of an item, the physical wear and tear. And those items could be physically depreciated in 2 classes, in either curable or incurable, which is an economic or feasibility concept. So for instance, at my house, I have a broken window. That's depreciation. It's not a brand new window, obviously, it is depreciated. And that's curable, not from the sense that it can be fixed, but that it's economically feasible to fix it, that it's worth it to fix it. There are also incurable physical depreciation items, such as the foundation of my house. It is not brand new, it has cracks, it's worn and torn over the 70 years. But it wouldn't be feasible to tear apart my entire foundation and replace it. So that would be incurable physical. So that's a very, very crude, excuse me, but very crude example of what depreciation is and in the 2 classes of it.
How about functional obsolescence?
Functional obsolescence is a loss in value or diminishment in value that is caused by or resulting from a change in market conditions. I'm sorry, a change in market preferences. So for instance, it's something internal to a property. So it's within the 4 corners of a property. And again, for simplicity, I'll use my house as an example. My house has an attached one-car garage, and hypothetically, let's say it does. And back when it was built, that was the norm. It's a 70-year-old home. However, people looking for a home today are typically seeking a 2 or 3-car attached garage. So while physically my garage is contributing to value, there's nothing wrong with it from as far as the bricks and mortar go. My home has a functional issue, or maybe the bathrooms are too small in my home because everyone now likes big, large, spacious master baths. So physically, while my bathroom is okay and my garage is okay, they don't meet the preferences of today's market buyers. And therefore, if I was building my house today and replicating it, it would be worth less than an otherwise newer home that would have the more satisfying larger garage and better bathroom or bigger bathroom. So it's a loss in value within the 4 corners of the property caused by outdated utility, maybe older kitchen, smaller closets, smaller bedrooms, but it's not a physical issue, it's a functional issue.
Did functional obsolescence come into play in your analysis?
No, it didn't in either the cost approach or the market approach, because all the comparable sales we used are all concluded generally to have the same issues. They're older systems that share similar utility in the sense of a benefit or an amenity.
On page 39 of your report,
Yes.
on the last line, it says, if a property suffers any functional obsolescence, it is necessary to utilize the reproduction cost estimate. Were any adjustments made for functional obsolescence of any asset that you reviewed as part of your appraisal?
No, I don't believe there was any noted in this assignment.
Could you explain for the commission external obsolescence?
Yes. External obsolescence is a loss in value to a property caused by some factor that is outside the 4 corners of the property. So for instance, again, for purposes of simplicity, I like to relate it back to a single family home. You can build the exact same homes, same size, same quality, same materials, same workmanship, make it identical in 2 locations. And the house might cost the exact same to build in a particular market area. So let's say the cost of the house with all labor, entrepreneurial incentives, profits, overhead, direct and indirect costs, and site value. Say the total cost to build those 2 homes is $300,000. And one party builds the house in a subdivision of other homes. And the second party builds the exact identical house at the exact identical cost in a location which is directly across the street from an operating landfill. In theory, although not a given, but you might expect in most cases that the house that is across the street from the landfill is going to have a lower market value once it's built than the house that's in the subdivision, even though they are identical and in the same time frame and in the same general market area. And the loss in value is attributed to something external to the property. It could be the odor, it could be the site, it could be the traffic, but there is something external to the property that makes it less desirable and has a negative impact on its value. And that would be an example of external obsolescence or external depreciation.
Okay, thank you. I do have several more questions, so at this point, I'd like to break for lunch and we'll continue with Mr. Batis after lunch. Let's restart 2:15. All right, we're going off the record.
You need to walk away.
I have to call, it'll call me. Oh yeah, but if you go to where the mute thing is,
Right,
switch audio.
okay.
Oh. I parked out front and then I moved it during that first break over there.
I should have moved it, but I just didn't even want to. I was like, no, it's fine. I'll pay the ticket. So, no, but either way, I'm gonna be 65.
Hey, can you all hear me from the hearing room?
I can.
Okay. I just didn't, I assumed I needed to enter a password and it never did ask me for that information, so I just want to make sure I was on. All right, gonna put you back on mute. Before we go, excuse me, before we go back on the record, I want to make sure Mr. Batiste is still there.
Okay, I'm here. Sorry about that.
All right, thank you. And Mr. Williams, are you present?
Yes, I am.
Thank you. All right. All right, and Ms. Bench, are you ready to go? Okay, let's go back on the record. All right, we are back on the record, and this is the hearing in case WA-2021-0376. It is 2/22, and we are in the middle of, I, Judge Sire, am in the middle of questioning witness Joseph Bates. Sticking with, I'm sorry, I didn't have that on. Did not have my microphone on. So, Mr. Bates, sticking with your report, your appraisal report, if I can direct your attention to page 46. So,
Okay, I'm there.
okay, got it. So there, you touch on the sales comparison approach. It states that the fundamental concept of that approach is the principle of substitution, which is defined as a valuation principle that states that a prudent purchaser would pay no more for real property than the cost of acquiring an equally desirable substitution on the open market. Can you explain, kind of elaborate on that principle of substitution?
Sure. The principle of substitution is one of the fundamental principles in valuation. And basically it states that one of the measures of value, one of the three approaches or one of the three measures of value, is to look at the property through the eyes of the market, through potential buyers and through the hypothetical seller of the subject property. Recognizing that in most cases, a buyer has other options or alternatives to satisfy the need or the utility or the desire that they're looking to achieve through the acquisition of the subject property. And so in a simple sense, again, we'll take it back to a residential property. If I'm looking for a house that has certain amenities that are desired by me, whether it be the size of the home, the location, the quality of the home, the school district it might be in, etc. The idea is that there are other sales out there that I could choose from or select from, and based upon what those properties sell for or are on the market for, will help narrow down the range of what the subject would be with in an open competitive market. Not unlike buying a car or any other tangible asset. In real estate, it's the same idea that there are other alternatives to the property. Every property is unique in its own way, but there are always suitable alternatives that could provide the same utility and benefits.
Okay. For the properties that were used in this comparison, were they looked at with the support from any other party, such as Flynn Engineering?
Well, all of those properties that were cited as comparable sales, they come to us, or we find them, right, through different resources. In many cases, they are properties that we're aware of because we have appraised them. And we being the three of us collectively, or maybe Elizabeth inspected one of them for an assignment she did. But the majority of the transactions that are identified were in fact either inspected and or appraised by at least one of the three of us. In many cases, because we were performing appraisals, we also would have been at some point in the process, normally at the inspection and early on, we would have been involved with an engineer for that assignment, because that's the norm, even though, again, the Missouri statute doesn't require it. That is the norm for these appraisal assignments in all states. So for, was Flynn Engineering or someone like Flynn Engineering present at some of those inspections? The short answer would be yes, in most cases, but not always. Sometimes that sales data comes through us through public records and research where we don't have the benefit of talking to an engineer about it, but in most cases we do, and we have.
Okay. I want to take you back to, excuse me, back to the definition or the description of the sales comparison approach. In that paragraph where it speaks on the principle of substitution, can you explain what the cost of acquiring means?
And generally speaking, yes, but I'm sorry, was there a specific reference to a statement that I could look at or that you're asking about?
In the, on page 46, in the middle of that second paragraph, I'm sorry, lost my place.
I think in the very first paragraph, Your Honor, there's a statement about no one will pay more for a property than the cost of acquiring an equally suitable parcel. The second one in the sentence, is that the reference?
Yes.
Okay. And you want me to comment on that and the relationship between cost and market sales?
Well, what is included in the cost of acquiring, I guess, is what I'm really seeking.
Well, the cost of acquiring typically means the acquisition, what it would take to either acquire an existing property that is already built and that is considered to be similar or comparable, or possibly even as an alternative, the cost of acquiring property and building a replica or a duplicate property. In this instance, or in this context here, the reference is to what it would cost to acquire an equally suitable property. So again, water utility and wastewater utility systems are very unique, and it's difficult for many people to understand the complexity of the sales comparison approach as it applies. So in a very general, simplistic example, if you will, again, if I'm looking at my parameters or my criteria for a home are 3,000 square feet with 3 bedrooms and 2 bathrooms. The idea is that I won't pay more for the subject property that has those features, the one I'm appraising. I won't pay more than $200,000 if down the street I can buy all the homes that are equally suitable, that have that same the same level of amenities for me. If they're all available and selling for $200,000, the principal substitution says I wouldn't pay more than $200,000 because I could go buy one of those. So it's basically just, again, a measure of a property's value based on what properties similar to it either have sold for or what they could be purchased for based on current sales or listings.
All right. When it comes to the cost approach compared to the sales comparison approach, were the results of the engineer's report that was prepared for the cost approach used to assist in deciding the comparable utilities for the sales comparison approach?
I don't know that they were necessarily and directly involved in determining which ones were selected. However, they are a useful resource in determining comparability or levels of comparability. Keeping in mind that engineering reports come in all sizes, shapes, and forms. So sometimes an engineering assessment or high-level report provides enough information on a comparable sale, one that maybe sold 3 years ago, that we can get out of that assessment enough information in detail to understand how comparable it is to the property we're appraising. And in some cases, there might be no engineering assessment report, or there might be one of very little detail, which isn't helpful in us understanding exactly how comparable it is. And that all is weighed and reconciled at the end of the process as far as which sales are given more emphasis in the final consideration than others. It's the quality and the quantity of the information that we had for those particular sales, because it varies from property to property and from comparable sale to comparable sale.
All right. In your sales comparison approach, under that approach, it's based on sales price per customer. But in your assessment, did you review the makeup of the types of customers for each utility used in that comparison?
Very good question, because that is a factor that in many cases is overlooked. But yes, we address it, and we actually use equivalent customer units or conversions when meters are oversized and for multiple users, like apartment buildings, et cetera. So we in our normal course of business, we research with the property we're appraising, as well as all the comparable sales, how many customers there are, how many of those connections are active, how many are vacant, what's their average monthly. In some market areas, depending upon what kind of properties we're dealing with, there are seasonal fluctuations. So we look at those. We also look at how many of the meters are shut off, but available to be turned on. Maybe they have a high vacancy factor in the community for unemployment or other reasons. We look at how many are residential units and residential customers and how many are non-residential. So for instance, I think in Eureka, there was even a situation where the campground was using some of the water. And sometimes there's users that aren't in the system for wastewater, but they're in it for water, or vice versa. So we look at all those factors and try to come up with a balance or an equivalent number of customers that we can then compare to the comparable sales. So we have apples compared to apples, if you will.
Can you direct the commission where in your report that customer analysis is?
That's not in the report. A lot of that type and level of analysis, and that's just one of the examples of how we go about comparing comparable data. It's not practical and typical to put all of that analysis into the report, because it would just be, it would turn these assignments from 60-page documents into 400-page documents, and it's just typically not what we recognize to be anticipated or needed by the typical user based on their intended use. So all the different type of metrics we analyze, and all the different levels of comparison, and we look at cost per foot of mains, how many connections they have in relation to how many feet of mains. These are all different analyses that we keep in our database that help us run and sort comparable sales to find the most comparable or similar at the end of the day. But it's not, all that detail is not included in the written report.
Okay, thank you. When it comes to the utility sales that were in your comparison, did you assess the value of the sales price per million gallons per day of those sales?
That's one of the pieces of data that we collect, but in many cases, we don't have all the details for all the sales. So that's one of the, I'd say that's one of the factors that is looked at depending upon and weighed based on all the other information we have. If we have really good, solid, and complete information on all the capacities, existing and current capacities, certainly that is something that is looked at. In many cases, like other factors to these properties, we don't have enough details to do it on every assignment. So, but it's one of the things that we investigate, yes.
So is the industry standard price per customer or price per million gallons per day treated?
The industry standard for valuation, this is what we refer to as a unit cost, and the unit cost varies from property to property. But in utility systems, absolutely, the unit cost that is typical in the profession, whether it be in the engineering field, where we sometimes see engineers doing cost estimates for a system, and then they equate it and communicate it on a per customer basis. Certainly appraisers, and then most importantly, when we talk to buyers and sellers, that's a common reference to sales when we are confirming data with parties, which is part of our responsibility with any of these market sales, is to confirm the sale date, the sale price, the conditions of the sale, any extraordinary situations or circumstances. And the most common reference dealing with folks like American Waters, like Miss Billups and Miss Pacific, or the representatives from Aqua or Central States or Liberty. When we call those folks and we are doing research with sales, the discussions are always in terms of X number of dollars per customer. That's the norm in the industry. That's the unit cost.
So there's no other metric that is used that's common practice within the industry.
Well, again, there's different metrics and there's different ways to break down and analyze sales and to bracket them based on different ratios of different components. But as far as unit cost goes, unit cost is a term in the profession which is the most commonly used reference to a sale price based upon some unit of the property. So let me give an example for hospitals. When hospitals sell, we talk about those sales not in terms of per square foot of building area, but we talk about them in terms of so many dollars per bed, or a nursing home. Hotels are so many dollars per room. Now that doesn't mean that the other characteristics aren't relevant, like the size of the rooms or the age and condition of the property. It just means that the reference to the sales price down to a basic element or unit that's easy to compare would be per bed or per room. And in the case of utility systems, it's per customer. Let me put it this way. The 15 years of doing this, I've never had a discussion with anyone in the profession or outside the profession who we deal with, market participants, who talked about a sale price or a value of a property in terms of this one is worth X number of dollars per gallon or per capacity or per gallons pumped a day. I've never even heard of that reference. So it's not common at all. It's not to say that it can't be done, but the industry norm is dollars per customer.
Okay. I'd like to direct your attention back to your report on page 70, which on Schedule JEB-2 is page 75 of 98.
Mm-hmm.
At the top of that page, that first sentence says that the Eureka Water System has 4,009 customers. Sales of systems with customer counts less than 550 were excluded from the analysis. If we go to sale number 2, which is on page 48. A water system with 567 customers. What features of that system made it comparable to Eureka's system?
Okay, well, comparability is a tricky word, and certainly used in our profession. There are so many different varying degrees of comparability and a lot of differences amongst these properties. When we select the comparables, in an ideal world, they would all be very similar in size, age, location, et cetera, and number of customers. The fact of the matter is they're not. So while I can't speak for every detail and every rationale that was used by Ms. Schneider in ultimately selecting which ones were the most comparable and the least comparable out of our total pool of, probably 50 to 100 sales. My best guess is that comparability had something to do with it being relatively recent. I'm speculating based upon our experience that if we went into the engineering assessment reports, all the cost data, the original cost and the cost less depreciation, we saw ratios that were similar to what was demonstrated for the subject property. I'm also assuming that this fell within our parameters for number of customers per lineal footage of mains, probably capacity issues were considered. I can't answer with certainty, but these are the types of things that we would look at to determine, does that particular property generally fall within or check enough boxes to be one that's representative of the range for the subject. Is it different from the subject in many aspects? Absolutely, they all are. That's the nature of the beast with valuing this kind of special purpose property. But a lot of the nitty gritty of, why this one versus that one, sometimes it just comes down to, hey, we know this one. We have high confidence in this sale because we appraised it, we inspected it, we had detailed engineering report. So we're very comfortable with what we know of it as far as how it ranks or compares, even though it might lack a lot of other similarities that we would like to see. But I can't tell you, actually for any of the comparable sales, why that one versus one we excluded. I just know that as we went through them and looked at the data that we have on each one, we get comfortable with a certain group of them, if you will.
Okay. And so you can't tell me what the capacity of, or how the capacity of this Sydney, Illinois system compares to Eureka's?
Not as I sit here today, no, sir.
And you don't know whether or not that system also had treatment facilities as part of its system?
Yeah, I apologize, but I do not have the complete file in front of me, and I don't know all the details of it as I sit here, beyond what's represented in the report.
And so for any of the comparables, you would be able to tell the commission whether or not those systems had, whether those systems were maintained and in compliance with environmental regulations and laws comparable to DNR's regulations.
Well, what I can tell you is that, what I can and can't tell you here, what I can tell you is that those are factors we are generally aware of, maybe not at the same level of detail in all of them, but those types of issues and questions are ones that are usually answered as we appraise those properties, and we have information backing up these files for each property. But I don't know, as I sit here today, you know, I can't fill in all those blanks, but that's part of the process we go through when we are selecting comparables. And sometimes we just don't have any information, and it's a sale that seems comparable on the surface based on a couple amenities and factors and different elements, but we don't know any of those details, and so we might use that sale and give it less emphasis at the end of the day, even though it might appear to be on the surface the most comparable. But we don't have enough trust in it to put enough weight on it because we just don't know enough about it. So that's pretty much applicable to all these sales, if you will.
Okay. On this particular one, this Sydney, Illinois, Village of Sydney, Illinois sale, the last sentence says, the system is a sequential system purchasing bulk water from Illinois American Water Company. At the time, I guess at the time this asset purchase agreement was signed in April of 2019, was that Sydney system already connected to Illinois American Water Company?
For the water itself, for the source of the water, yes, they did not have their own intake or wells, but the assets weren't owned or controlled by American. So sometimes these sales include just components of a system. For instance, a community might sell off all the processing, but not the collection system, or vice versa. So the understanding of what the assets were that were included, and being able to having the benefit of reviewing an engineering assessment pertaining to those specific assets is what assists us as a tool for determining comparability and why maybe that unit cost is higher or lower than and outside the range, if you will, of the others.
Sydney's water system, on that page it says pending. I assume that means the sale was pending at the time that it was used in your appraisal.
Correct. And it has subsequently closed.
Okay, and there are several that also say pending. Is that not true?
That is true.
Okay. But are pending sales allowed to be used in appraisals under Missouri law?
Absolutely. The appraisal standards and use PAP, there's absolutely no language and no restrictions on what is considered a comparable market data for an appraiser to consider, whether it be a sale, a pending sale, or even a listing. We've completed appraisal assignments where we had no sales of properties, but we had 5 listings. That is appropriate under certain circumstances. So yes, the inclusion of pending sales and other types of market activity, offerings, contracts, listings, all of that is considered relevant market data.
But isn't it possible, though, that a pending sale used in your analysis can conclude with an actual sales price that's widely different than what the pending sale price was?
Well, of course, anything's possible, but our research and experience shows that when these systems, particularly in Illinois, when they go to a purchase agreement and the price is agreed to, I can't think of an instance where one of them didn't sell at the pending price, at the contract price. Could there be adjustments to those prices? Absolutely. But that would be the exception, not the rule.
This particular sale, again, and it may sound like I'm picking on the village of Sydney, Illinois, but is pending sale information, pending sales in Illinois, is that a public record?
It becomes public record once the asset purchase agreement is filed with the Illinois Commerce Commission and is part of the docket. Then it's available to the public. So during the process of the approval and the consummation of the sale, sometimes those APAs are public and are available. Some cases they're not disclosed until after the sale is closed. So it varies.
All right. I'd like to direct you to page 70 of your report. On page 70, it's where you have concluded that a unit price of and this at the bottom of the page, unit price of $4,500 per water customer for the subject property water system. Can you explain how you arrived at that unit price?
Well, generally, yes. The same process we always employ, which is after comparing these comparable sales and the reviewing the information that we have available, whether it be through information we obtained on our inspections or public information, through engineering assessment reports or other types of reports. We rank them and we rank the comparability of each to the subject property. And if the subject property is deemed to be superior to all of them in most categories or elements, it would be it could be at or above the range of the comparables. Likewise, we've had systems that we've appraised where they are in such poor condition that their concluded market values are far below the lowest price. We've had systems where pumps were being powered by power extension cords that were running across properties and plugged into a box in a field that didn't meet any codes or requirements. Systems that are at that level, if you will, would reasonably be expected to be far below all the comparable sales that don't have those issues. So it's a matter of the reconciliation process is one in which you take a step back from all of your data and you look at it. You look at the cost of the system, the subject system. You look at the cost of these systems relative to the prices they sold to see where the subject fits. How much depreciation has the subject property experienced compared to relative to its cost compared to the others? And at the end of the day, that analysis leads us to a range of value that we must pick a unit value from, which in this case was 4,500. But there's no simplistic, it's this one times 3 or this one plus 10%. It's unfortunately for this type of property, it's not that simple. Just an overall review of all the data and a reconciliation of all of it and the quality and the quantity of what we have to work with.
Okay, but at the top of that page, when I look at the other systems that are being compared, the highest per customer is $4,157. So I know you say that this Eureka system has features that justify $4,500 per customer. I would just like you to explain to the commission why that is. What features make it more valuable than any of these other comparable properties?
Well, I don't know that I can put a finger on the exact reason why it's the highest. Again, when Ms. Schneider goes through this process and analyzes them and looks at the different metrics and the comparisons and looks at the engineering reports and the cost data, that's her strength, if you will, her major contribution to this process. And when we walk through that analysis and it's explained to us of why the subject falls at this range or above this range, we look at it unless something stands out that flies in the face of it, if you will, or it seems to be inconsistent with the data or the other approach to value. It normally is a reasonable conclusion. But I can't tell you that these are strange birds, if you will, and it's not like a house where that one sold for 100,000 and we know its location is 10% better, so the answer is 110,000 or to 90,000 if it's 10% superior. These assignments don't fall into that category, and the process is not that simple to quantify the adjustments and quantify the end result. A lot of it comes down to judgment, experience based on being able to view and investigate the other sales and understand what they were to conclude ours is better than that. Ours should be at least 10 to 20% higher than that range. That comes with experience and it comes with understanding the data, but unfortunately there's no equation or no simple answer to quantify it.
All right, thank you. I want to switch gears to the wastewater system, and that is just, in your report, it starts on page 71, so just the very next page.
Mm-hmm.
At the bottom of the page, it says, the most comparable properties would be those that include a similar number of customer accounts for the sewer system, although other differences such as age/condition, location, and market area must be reconciled. In your sales comparison approach, were there adjustments made for differences that would impact the value of the system?
Not quantitative adjustments that we'd be accustomed to seeing in other types of appraisal assignments. More of a qualitative analysis.
And then similar to my question about the water system and how you arrived at $4,500 per customer, how did you arrive at $2,500 per sewer customer?
It would be the same explanation, sir, that I provided with respect to the water, which is going through each one of the comparables, trying to get an appreciation for what type of information we have, how thorough it is, how reliable the information is. Was it firsthand information or information that we gained through sources that all the blanks aren't filled in? And then we started looking at the metrics and the different ratios. And again, ultimately, through our experience and judgment, we get to a point where we get I hate to put it as a way like a warm and fuzzy feel or comfort feel for where the property is, but the data starts to point to, when you look at those different ratios and different metrics, it starts to point to we're in the higher end of the range, or we're in the lower range, or maybe we're just kind of in the middle. There clearly are, the data is not perfect, and there are clearly some systems that seem to be very similar to sold for more, and there are some that seemingly are very similar that sold for less. And sometimes there's some unknowns or some vagaries in the sales data that can't be answered for, and it might justify something more in the middle of a range. But unfortunately, there's no science to this where, again, like traditional appraisal assignments, we can capitalize an income and measure things on so many dollars per unit value and the adjustments based on that same quantitative method. That process does not work with this type of data, unfortunately. So there's no simplistic answer to it.
Right, and I believe you maybe even use that phrase in your report. It's an art, not a science.
Clearly, yes.
And similar to your appraisals of water utility systems, is it industry practice that your metric is sales price per customer as opposed to any other type of metric?
Again, I'd answer that by saying that's the most common way to express prices and to compare systems on a unit basis, just like it is for every other appraisal assignment. Office buildings, we talk about what is the price per leasable square footage. Industrial buildings, it's what is the asking price per square foot, or what is the rental price per square foot. Land, how much is the land worth per acre? Can you also analyze land on per front foot, per depth, land to depth ratio, per square foot? All of those are an absolute yes. But the most common way to compare them on a similar basis is price per acre. That's the norm. In the utility system valuation assignments, it's probably the only method that is used for expressing sale prices and values is a price per customer.
Okay, if I can direct your attention to page 6 of your report.
Page 6?
Page 6. On the schedule, it's page 11 of 98.
Yes, I'm there.
So at the bottom of the page, it shows date of physical inspection of the property, December 10th, 2019, and March 18th, 2020. And then it also says, it also says a few lines later that multiple site visits were conducted between December 10th, 2019 and March 18th, 2020. Who did participate in the March 10th, 2019 site visit?
Well, I inspected it on that date. I may have been the only one on that date. The other appraisers, I think maybe we had that scheduled, as I talked earlier. I think possibly that was a date that was tentatively set for whoever could make it on the first inspection to get the assignment going. And it's very probable that the other appraisers, based upon the emails that my memory was refreshed with earlier, that they made inspections on subsequent dates. But clearly I was there on December 10th.
Okay, and Ms. Bretz asked you earlier about the email. It's her exhibit 108, page 97, 98. That was your December 10th, 2019 email that was sent at 9:35 a.m. And that email is trying to make arrangements to schedule a site visit with Mr. Dinan and the engineer. So it strikes me odd that it's 7:35 a.m. So would you have made that site visit and had already decided by 9:35 a.m. to make another site visit?
Absolutely. You know, may I explain?
Sure. That's why I asked the question.
Okay. I don't know if you wanted a yes/no answer or if you wanted me to elaborate. So very, very often these assignments, because of a number of reasons, because of the idea of turnaround time, expected delivery date, whether we talked about that earlier, whether or not it's a rush job or how soon it needs to be completed. Sometimes there is a time pressure. There's also weather and travel considerations. I drive, and that's maybe a 5-hour drive for me to get to that location. For Elizabeth, it's maybe an 8 or 10-hour drive. We all have our own practices, all the appraisers and the engineer. So coordinating a date on short notice that we're all available to is sometimes very difficult. Of course, there's weather considerations that even though the weather might be fine down there, Elizabeth's driving from Wisconsin, so she may not be able to, because she doesn't fly down, she drives. She may not be able to get down to an appointment because of the weather in her market area. So instead of putting off inspections until everyone is available and the conditions are ideal for all of us, including the host of the meeting, which in this case is the city of Eureka and its officials and its staff. It's not uncommon for me to take the lead or one of the other appraisers, but typically I will call the client and say, look, we're approaching holidays. It might be weeks or months before we find a date where everyone is available. Can I call the city of Eureka? Can I have a contact where I can call and go down and meet them? Go out and inspect the properties, because again, I focus, a big part of my focus is the land values and the easements and the parcel sizes. And I can go down and start collecting data on the sites and the locations, view them so I know what kind of properties we're dealing with. Are they residential properties in town? Are they water sewer locations? Are they well and septic locations? Are they sloping and hilly topographies? Are they level buildable land parcels? But very often, the inspection is not had or does not take place with everybody at the same time. On occasion, it does. In this case, based upon as I look back and went back and found my photographs and the dates on the photographs, I recall specifically being there, driving down early the night before and staying overnight, and getting there early in the morning for the appointment that was scheduled just for me, with the expectation that I could be back home with my 6 or 7 hour drive by evening. And I can say with confidence that now as I think through the process and look at the emails, that once I got there, I worked with the staff and whoever was there on the city's behalf to start coordinating what would be a good date to get the other appraisers in when their schedules allow. When is the staff available? Are there going to be breaks during the holidays or days where people won't be available to drive us around and take us around? And it wouldn't surprise me at all that I was there for an appointment at 8 or 9 in the morning. We always start with a meeting in the office to go over all the particulars for the assignment, and that at that time that I started the process of picking a date and suggesting a date and coordinating a date for the other appraisers and engineer to come down. And that's a very typical process. So the timing of the email does not surprise me at all. I think that's very reasonable based upon how we go about this in instances when we can't all be there at the same day.
And you mentioned photos. You took photos on December 10th?
Yes, sir.
Do you recall what you took photos of?
All the different locations when I went out on the inspections with representatives from the city.
So, well sites, storage tanks, et cetera?
Yes, sir. Lift stations, pump stations, treatment plants, towers. If there was excess land or excess parcels, buildings, structures, whatever was identified at that time as being part of the proposed sale assets, they would have been, inspected and photographed.
And in those emails, it looked like you were trying to arrange for maybe a December 17th, 2019 site visit that everyone could participate in. Did that site visit actually occur on the 17th?
Well, I know it occurred, but I don't know if on that date. I can say with certainty that the others inspected. Obviously, that email was trying to, as you stated, was trying to coordinate. The purpose of that was trying to coordinate and get everybody down there. I don't recall what the replies and responses were, and if they all made it on the 17th, or if they ended up finding a date that worked, an alternate date. But clearly that's what my objective was.
Were you there on that, and whatever date it was, the 17th, 18th, were you there that date?
No, I believe my next inspection date was in March.
But do you know who would have made that second date in December?
I don't recall, no. You know, and I'm not even sure it was a second date. It's very possible that Ms. Goodman Schneider and Mr. Dinan ended up making their own appointments individually. I just don't recall. Pretty much left that to them to work out instead of trying to be the middle person or middleman. And I threw a date out and said, can everybody be here next week? And whether they made it that date or made their own inspections, I don't know as I sit here today. I could try to track that down and reach them, but I don't know.
And then you mentioned that March site visit, March 18th. Well, first of all, what was the purpose of that visit, since it was only 5 days before the report was released?
I'm not sure. I'd have to go back and look. I'm not sure if there were some either additional assets or something I missed or still had questions on. It's not uncommon if I'm working on an assignment and I might be maybe down in the region working on something else, that if I have to either follow up and go check on something about a building or maybe go look at the land sales, that I would go back down to the property for a second view or a third view. As a matter of practice, I don't do that. As a matter of policy, I don't do that practice. But there are times when I'll go back and look at it again. Could be for a number of reasons. I'm not sure what it would have been.
So you were there that date. You were there on the 18th.
Yes,
yourself.
Sir. That's what my
tell-
notes in the records. That's what my notes in the report indicate.
Right.
And,
I understand. I can't account for every day of my life.
right.
Sure.
I don't have time to remember what I did last week. But I think, yes, my best, most certain answer or most confident answer would be yes, I was there that day.
Do you recall who else among the appraisers and engineers were there that day?
I can check with them, but I don't recall. I'm down in that region every 6 to 8 weeks looking at properties and doing something, and I don't recall who was there, unfortunately.
Okay. Can you pull back up Exhibit 108, which contains the emails?
Okay, I have the exhibit with me in front of me.
All right. And on page 101 of 128, it states, and again, this is from you to Mr. Dinan, Ms. Goodman Snyder, Jordan Liner, and Kelly Simpson. You write, hello, just checking in with everyone to see if you had a chance to review any of the documents yet. And if you could send me an email about your availability to re-inspect Eureka so we can get this report finished in the next few weeks for the client. And then you say, Elizabeth, I can recall that you were fine with your inspections and did not need to come back for a second trip. When you use the word re-inspect Eureka, what are you referring to?
I believe that, well, earlier today, this morning, I testified that there may have been some circumstances on this assignment regarding an inspection where we showed up and the community wasn't ready for us in one regard or another, whether it was staff or documents or whatever it is. When we got there, there was a misunderstanding of why we were there and how much time we needed to go see, because this is essentially a full day of inspections, going out in the field, looking at all these properties. And I recall, as I testified this morning, that this somewhere in the process for this system, for this assignment, there was something like that came into place. Something caused us to reschedule. As I went back and looked at my notes, I found that we originally met down there, all the appraisers, in, I think it was August of 2019 when we were initially contacted about and all engaged to perform the appraisal. I think we went down there and it was probably premature. I think we were, like we do in many cases, we get hired, we look at our schedules, is it better to go this week, next week, in 3 weeks? It so worked out in August that everyone was available and could meet there. It was convenient. And I think we did it. And in retrospect, I think it probably wasn't a good choice because there was either misunderstanding or they weren't ready for us or they didn't have everything we needed. And so while we were there and were able to see a few of the assets and visit some of the sites ourselves, using the maps that we had and going out and look at the plants, it wasn't the full scale inspection, and we all agreed to reschedule it.
Okay, so you would,
I believe this email is referencing that reinspection.
okay, so you wouldn't really categorize that August visit as an inspection.
Well, I do from the point of the inspection entails several items or several things. It includes the opportunity to sit down with, typically with the seller. It could be, in this case, I think it was Mr. Sabo, but it could be someone from his staff or a clerk. It could be the director of public utilities or the director of the water or sewer department or utilities department. But when we commonly and generally use the term inspection, it includes several things happening. One is obviously going to the property, meeting with representatives, interviewing them, gaining information and knowledge about the system, where the assets are located. We have a series of questions that we go through. We start talking about documents that we would like, maps and so forth, details. And then of course, there's the on-site physical inspection of each location. And that could be a drive-by. It could be get out, park the car, walk through the buildings, measure them. So, the term inspection is used loosely in our profession, and it could mean a number of things. Whether it's categorized as an inspection or a meeting or whatever, we obviously were all there in August, began the process of collecting information, and needed to revisit and come back on a second occasion to continue. So whether those are considered inspections or not, to us, it's all just part of the process, I guess.
When you say we were all there, do you mean Mr. Dinan, Ms. Goodman Schneider, Ms. Simpson?
I mean, Ms. Goodman Schneider and Dinan, and by Dinan, again, it could have been anywhere from 1 to 3 people from their office. Ms. Schneider and her husband and myself.
So not the engineer, not Kelly Simpson.
I don't recall if she was at the August meeting or not. Again, typically she would have been, because we try to coordinate and with the community and try to not inconvenience them by being there multiple times if possible, though sometimes that's unavoidable. So you'd have to check with her, but I think she probably was there in August, and then but I don't know with certainty. I can't answer that.
Okay. All right, those are all the questions I have.
Thank you, sir.
Thank you. Mr. Williams, do you have follow-up questions?
I think just a couple, probably. Mr. Batis, you testified that you had, I believe, or have had a relatively long-term relationship with the other two appraisers. Is that not correct? I'm sorry, I can't hear him.
My apologies. I accidentally hit the mute button. My answer was, relatively speaking, yes. I think I've known them for 5 to 7 years.
Is that true of Ms. Simpson as well?
I would say about the same time frame. Yeah, I probably met Miss Simpson within the last 5 to 10 years.
And you've been working with her over that period of time as well?
Working with her occasionally, we're on the same projects, but yes.
No further questions. Thank you.
You're welcome.
Ms. Pratz, do you have questions?
Just a little bit, thank you. Mr. Batis, I don't want to belabor the point, but the December 17th, 2019 visit, that was a canceled visit because of the bad weather, right?
You know, it may have been. Again, I know I was there on the 10th, and I began the process of trying to coordinate this December 17th. I think you're right. I think that was canceled because of weather, but again, I'm sketchy on the details of exactly what dates in December were scheduled and which ones were canceled. I know there were multiple inspections down there.
If you could turn to page 30 of Exhibit 108, please.
Is that the email exhibit?
Yes,
Okay, page 30.
yes.
Okay,
So the first email at the top is an email from Mr. Sabo to Ms. Simpson, Mr. Dinan, and yourself, dated Monday, December 16th, right?
correct.
And the email reads, Kelly, I will inform David and Dave that the meeting is canceled. Dave Scott's email address is such and such. It looks like Mr. Scott and Mr. Rick are employees of the city of Eureka. That's what the email says, isn't it?
Yes,
So that's definitive that that meeting was canceled, right?
yes, it appears that that was because of weather, yes.
And so that means there was no inspection on December 17th.
Correct.
Before we took our lunch break, you discussed an appraisal report dated January 20th, 2020. Do you recall that?
Yes.
Would you happen to be aware of whether this report was made available to staff?
Unfortunately, no, I don't know what was submitted to staff.
Okay. What's the difference between this January 20th, 2020 report and the one that's been entered into evidence as Exhibit 3?
My recollection is that the original report from January, our appraisal report was based on some original analysis and work that was done by Flynn Engineering, where at that time, I believe there was a certain number of assumptions that needed to be applied or used by Flynn Engineering to conduct their work or to come up with their work product. And I believe that, as often is the case, the assignments are typically put together with whatever information we have, which it always isn't the most complete. And then in some cases, like I believe was the instance here, additional information came to light, which filled in some of the blanks, if you will, or allowed Flynn Engineering to not have to rely on assumptions, but was able to actually used some information that was researcher obtained or provided, which changed her analysis, her assessment, her list of cost data, depreciation data, contributory costs or depreciated costs, all of which are key to our work. So we adjusted our report once we received revised work from Flynn Engineering.
Do you recall what the new information was that Ms. Simpson received?
I don't recall specifically. I can speculate, but I don't recall exactly what she received. I just don't recall that.
Does your later appraisal mention the first appraisal?
No,
Any particular reason why not?
not relevant, not necessary, and would serve no purpose. I appraise properties very often that have where something during the course of the assignment, something changes and we revise the appraisal or update it. And if it's still part of the original assignment and it's not a new assignment, that's not something that has to be reported or disclosed. It's very, very normal in our profession that information comes to us, which we believe is all the information that we will be getting or will be receiving or have available. And then we write a report and we find out that, oh, here's a survey that shows there's 4 pipeline easements on that farm. So the report is revised accordingly. Just a normal course of business, and doesn't require us to go back and talk about the changes that we had to make to get here. Doesn't serve any purpose.
What was the amount of your original appraisal?
The amount of the value opinion,
Yes.
I don't recall.
You're in front of your computer there. Is there any way you can access it?
Sure, I can look back if you don't mind waiting a few moments. Actually, this database does not have it. This just has the current work. I'd have to go back and see through a network later where it is, but I do not have it in front of me. I only have the updated current valuation.
Do you recall off the top of your head how much it was? Was it higher, lower, how much?
I recall it was lower, but I do not recall by how much or what it was.
Judge Sayer asked you a number of questions about how the appraisers reached the $4,500 per customer unit price for the water system. And I have to apologize. I misrepresented that the Village of Sydney was the most expensive water system. Maybe I had a sticky on top of the other one. But anyway, can you shed any light on the particulars of the Eureka water system, why it should be valued on a per unit basis higher than any of the other comparables you looked at?
Nothing beyond what I already explained to His Honor, that it's a process that includes a reconciliation of a lot of data and ranking of properties and ratios of different assets and components, weighing the quality of the information, meaning is it firsthand that we've seen the system, we've appraised it, we know what is there, versus is it public information where details are sketchy. Beyond that testimony and that explanation, no, I don't, unfortunately, there's no magic formula like there is for a house appraisal that I can say, well, it's this plus this percent. That doesn't apply in these cases.
So there are no specifics about the Eureka system that makes it more valuable than your most expensive comparable?
Well, again, it's the overall comparison to all of the data and what we understood about the data. We found it to be obviously superior in whatever the different aspects were, but we found the water system, because of its condition and the assets and what we knew of it, to be superior, considerably superior to some of the sales that we had an equal amount or certain amount of information about, that we understood what those assets consisted of, and we knew what they sold for. So we knew it was superior. It's called, in the appraisal profession, it's called a qualitative analysis. There's no pluses and minuses and percentages and itemization of them. It's just bracketing of data and trying to figure out in the spectrum, are we above the highest sale? Are we within the range, but at the top of the range? Are we comfortable with everything we've known and seen in research that this property is ranks towards the bottom on a relative comparison basis? A ranking and qualitative analysis, unfortunately, it's based in great deal on our formal education and training, our experience, our firsthand research, and there's no formula or way to explain it. A lot of it comes down to judgment.
That's all I have, thank you.
All right.
Pardon me?
Judge, if I might make a suggestion at this point.
Go ahead.
Public counsel would not have any objection if the commission were to direct the company to have the earlier appraisal report made a part of the record in this case.
Mr. Cooper,
Yes, sir.
would you like to respond to that?
Yeah, I would. But you give me just a minute, Jeff.
Sure.
Yes, Your Honor, we have no problem with that.
All right. All right, then, Mr. Cooper, do you have redirect for your witness?
I do. Mr. Bates, just to kind of start where we finished here, you were asked about the $4,500 per customer appraisal for the water system. Is the sewer system appraised at higher than the comparables that the appraisers looked at?
No, I believe the conclusion of value for the subject sewer system was more towards the middle of the range of the comparables that were cited and relied on.
And those are included in your in the evaluation report, correct?
Yes, they are.
And early in your testimony today, you had mentioned that you helped select and I guess kind of deselect, not include some of the comparisons that the appraisers were aware of. Is that correct?
Right. Some that we're aware of and we're I was talking about the process of whether or not they should be included in this assignment.
And were the appraisers aware of per customer sales prices that were higher than those for water systems that were listed in the valuation report?
Substantially higher, some probably double the price of what's referenced and included in the appraisal report. I think there were sales that were over $10,000 per customer that are part of our data pool.
And in fact, when we look back at, I think it's JEB 3 in your direct testimony, there's some of those numbers are present in those materials, aren't they?
Yes, that exhibit includes 9 examples of data from different appraisal assignments, not my reports, but other appraisers' work. And some of those examples include references to sales that were at or above $10,000 per customer.
You indicated to early questioning that you requested the Flynn report, correct?
Yes.
What was the assignment for the Flynn report?
Well, the assignment was, as is typically when we get involved in these, the request for Flynn to provide the appraisers with a report that does a couple different things. Provides a list of assets or an asset inventory. Usually we want the current cost and the best estimate, if you will, or calculation of depreciation of the items based upon some age life or modified age life method, and a depreciated cost, which is a contributory value of the different items. And then we also request or expect to receive some type of broad or overview or high-level commentary on the system based on whatever information is available, which sometimes is very scarce and limited and sometimes is quite extensive. But based upon what she or they are able to research and provide us as far as an overall condition assessment, recognizing that it's a difficult challenge because when you have a system that varies in age and in all different types of assets and some you can inspect and some you can't, it's hard to sum down into one word: good, average, or poor, or fair, a fair representation. But that being said, we try to communicate and get a feel for how it ranks. And we have a pretty good understanding of what an average system is through Flynn's eyes compared to other work systems we've done and seen detailed assessments and cost calculations. We've seen examples of Flynn's work compared to other engineers on the same projects in Illinois where there's multiple engineers. So we trust in and we have high level of confidence in the ability to give us a simplistic overview, high level review of how does the system rank. And that helps us with our analysis and in our ultimate selection of comparable sales data.
And to you, from that answer, I take it it's important how it sort of relates to other systems that have been reviewed.
Oh, absolutely. Having the benefit of the extensive research we do and the records that we keep on other facilities and the different ratios and metrics that we analyze and our database runs for us, we also have a certain sense of objective analysis in there. This system was rated average by the engineer. This system had an overall depreciation of between 30 and 50% of all the different assets of water assets. And when you remove the mains and you concentrate on just the mechanical systems, the pumps, the processing systems, the treatment facilities, the depreciation was at maybe a different level, the range. So we take I keep a very extensive database. I take all the assessment information, all the inventory information, all the cost data, all the depreciation data, and the overall, it's a good system, it's average. And I use that when we're evaluating sales to determine comparability. Because if it all comes from the same source and through the same channels, we know we have consistency.
You were asked questions about, or pointed to some emails between you and I think Ms. Billups from Missouri American Water Company. Was there ever a point in time where the company had influence on the valuation opinion?
No, not on this assignment, not on any assignment. We don't ask what clients, we don't ask the seller, we didn't ask the mayor or Mr. Sabo what they thought it was worth. And we don't solicit any opinions from anyone. We are expected to be, per our licenses and USPAP, to be objective and fair. And what the client thinks the property worth is of no relevance or issue with us.
I think in response to some questions earlier, you were estimating how many utility appraisals you had performed in your career. Is that right?
I was trying to calculate this on the fly, but yes. I don't know how accurate it was, but I did.
Quite a few anyway, correct?
I would say compared to every appraiser I know and people in the industry, I probably do as many as anyone, yes.
Was there anything out of the ordinary in this appraisal in terms of the involvement of Missouri American or Eureka?
Nothing at all, sir. Very, very typical process as far as timing, flow of information, information coming in bits and pieces and chunks. When you think you have information, then all of a sudden there's more. Just part of the process, and that's, some of the communities we go to have zero records. And all the employees, we did one a few months ago, every employee just quit, walked out. The clerk that we're dealing with couldn't tell us a thing about the system, its age, when a dollar was invested. So it's all over the board, but I would say overall, the Eureka process, the assignment, very, very typical and nothing extraordinary at all.
You were asked questions about an email that discussed a Plan B. Do you remember that?
Yes.
As I recall, that involved Ms. Simpson. Did you ultimately follow a process that allowed Ms. Simpson to move forward with her work based upon pictures?
Yes, I believe the Plan B reference was kind of okay, we've got to do something other than what was planned, whatever that might have been as far as the inspection goes, maybe December 17th. And because of the timing and the schedule that both the client were on and the seller, as far as some deadlines that needed to be met, and with our contract as well, it was determined that Ms. Simpson could provide us what we needed, satisfactory to our level of need, through descriptions, photographs, and her own research that she would be conducting personally. So I think I, or maybe somebody from the team, forwarded to her the photographs we had and whatever information we had collected.
And I believe you were asked earlier by the commission whether the commission could obtain copies of those photos, and you were going to look to see whether you still had those photos. Were you able to find those photographs?
I found, not all of them, but I found enough to know in a work file that that they exist and they're there, and I can track them down through the other appraisers if I don't have all of them. Yes, I did that during the lunch hour.
And these are photos that you took yourself, is that correct?
Yes, on December 10th.
And you know it's December 10th, how?
Because I went into the properties on a couple of them and checked the dates and the time and date stamp of the photographs matches what I now recall happened that day. I was down there very early for my initial inspection. And I could see for the photos that I was able to locate, the time that elapsed between photographs, that I was there for several hours.
You were asked questions about DNR issues. Would you normally adjust to that level in an appraisal and evaluation report?
Yeah, no, that's far beyond what a professional appraiser is trained and qualified to do. Most appraisers, we try to take into account all relative information that is within our wheelhouse, that we know how to collect, verify, how to process it, analyze it. That type of information is not something that is factored into our equations or our analysis, our qualitative analysis, because we know those situations exist with the majority of the data, and with most of the properties that we've appraised, we even have indication or records or proof or evidence that there might have been DNR issues or environmental issues. I mean, that's normally the case of why these systems are being acquired, because they've got to a point where they're not brand new, operating at 100% state-of-the-art efficiency. It goes with the territory, and we see that in most, if not all, the systems. So it's not something that is extremely value influencing that needs to be adjusted by us.
Again, you were asked questions about how many reports or how many evaluation reports you've done in Missouri and elsewhere. Has every appraisal that you've done of a utility system resulted in a sale? A closing of a sale, I guess I should say.
No, as far as it's the best of my knowledge, no. From what I understand and my research, my subsequent or follow-up research, I'd say the answer is no. Some have, but not all. I'm sorry.
And how do you know that? Do you follow up on your appraisals after the fact?
Absolutely. I make it a habit to, it's on my calendar, to reach out to certain clients several times a year and to ask them specific information about assignments that I was participated in, as well as other projects that I'm not involved with or haven't been involved with. And I confirm with them closing information that I obtained through public records, like, for instance, the sale. If I do see a sale that was completed and finalized, and there's a filing in a docket, because I have my own researcher that just does nothing but look at dockets for that type of information. Very often, he also does Google searches of all the communities that we've done work in to see if there's any news or publications about sales or pending sales or consideration of transactions or votes being taken. So we try to track very closely and build up our database with after the fact, after we do an appraisal of what occurred, when it occurred. We get firsthand verification. And then we start following up with additional information such as economic and financial information and capital investments, tariff and information. So yeah, we do quite a bit of follow-up with each transaction, or I should say with each appraisal.
In questions about your expertise as to appraisals, I think you mentioned that you instruct on that subject matter. Would you explain that?
Yes, I've been an appraiser for 38 years, and I'm quite involved in teaching and being an instructor for different organizations, primarily the Appraisal Institute. And as I got very involved in the evaluation of water and wastewater utility systems in the last 10, 12, 14 years, I found there to be a lack of resources and educational material for our profession. Literally zero classes, seminars, workshops, writings, books published, no material at all to assist appraisers who want to understand the process. So after many years of working on a project with the assistance of many appraisers, engineers, representatives of the water and wastewater communities, talking to village representatives, I developed a seminar that is used for training purposes and educational purposes for designated and certified, state certified appraisers, to teach the methodologies and the process of everything we talked about: collecting information, inspecting properties, analyzing sales data, researching data. So I've developed the material, and I own it, so I'm the exclusive instructor for it, for the Appraisal Institute chapters that I teach it in person and online. And it's approved in the state of Missouri by the Missouri Appraisal Licensing Board. They have seen the material and approved it for a seminar for continuing education credits for its licensed appraisers in the state of Missouri.
In your direct testimony, and this is within your valuation report, on, I think it's page 11 of 98, there is a definition of market value that you were asked about. Do you have that in front of you?
I do.
I'm curious if you could expand on the part of the definition that says, I guess, the most probable price of a specified date, for which the specified property rights should sell after reasonable exposure in a competitive market. Can you expand on what's meant there by that part of the definition?
Sure. A real estate appraisal opinion, or an opinion of value, is a professional opinion based on a number of things. Obviously, research, data, experience, education, judgment. But it presumes a hypothetical sale as of a date. So let's put aside for the moment the subject instance. But again, somebody who owns a house. If I was selling my house today, what would it sell for? What could I expect to sell it for? That's the problem we're called to solve, if you will. And that opinion of value, if it's a market value opinion, is because there are different types of value. There's assessment value, tax value, value in use, insurance value. Courts have defined a particular value called special value that has, value unique to one particular buyer or set of buyers that aren't typical of the market, et cetera. But market value is the more general and broad value estimate that represents if a hypothetical buyer comes forward who is not under duress, but is a willing buyer, knowledgeable, acting in their own best interests, what they would be willing to pay for the property. Now, the property could sell for above market value or below market value, but a market value opinion, the objective is to opine as to at what price or price range or level the property should sell for in a typical market under typical conditions, without a buyer acting under a duress or a seller. For instance, if a seller has to sell the house because they got transferred and they have to move out of state next week, the property might sell for a fraction of its market value. It'd be a duress sale. So, but market value eliminates all those types of extraordinary circumstances and just says, let's talk about a typical scenario, what a property should sell for hypothetically. And that's the objective of the subject appraisal.
If we turn on over to page 15 of 98 in that same document, you were directed to earlier that sentence about Missouri statute pertaining to the valuation is required, or the professional engineer's report is required. And I think you testified that was essentially a typo, that the Missouri statute does not require that. However, are there other states whose statutes similar to this appraisal statute specifically direct a professional engineer's report?
The states that I have experience in, and even some that I'm licensed to do business in, but I don't necessarily participate in assignments there, but I'm very familiar with their legislation. that is the norm. Now, from state to state, this is not exact, template legislation where it's duplicated each time a new state enacts legislation. But there's a lot of similarities from state to state. But there's also some differences, and Missouri is unique in a few ways. One of them is that they're the only state that I can think of, or one of the very few of the 12 or 15 that I know of that have legislation where an engineering report is not a required component, but still used by appraisers, but not necessary.
The statute does require, however, a disinterested appraiser, correct?
I'm sorry, could you repeat that?
Does the statute in Missouri require a disinterested appraiser?
Oh, yes, that's absolutely a mandate that the appraisers are disinterested.
How do you define disinterested?
Let's see. Well, one way is, I guess. Sure.
Differently. How would the appraisal standards apply or define disinterested?
Disinterested party is addressed in one of the mandatory requirements of Standard Rule 2 of USPAP, which is the inclusion of a certification. And if you look at the appraisal report that we prepared, I believe there should be a signed certification from each of the 3 appraisers as required by law and by Missouri code because of its the mandate to follow USPAP. And that certification includes, amongst other statements by the appraiser, a affirmation that the appraiser has no interest, present or contemplated, in the property being appraised or in any interest in the property and no relationship to the parties. So disinterested means, it doesn't mean you don't know the client or you haven't done work for the client or it's not a good client or anything to do with frequency or volume of work. It has to do with having you're not related to them, like it's not a corporation that I own or own part of, and that I have no interest in the property itself, or I don't contemplate having any interest at the date I do my appraisal. So I think that kind of explains how disinterested is interpreted by USPAP.
In response to questions from maybe the bench and from staff, you were talking about, I think, sort of a number of issues that all kind of fit into the jumble of considerations when you're coming up with a price. I guess it's reflected in price per customer. For a price per customer, when you're also looking at comparables, would potential for growth in the market area, would that be one of the many factors that would have some impact for you?
Yeah, I think that is certainly, I don't know if I mentioned that specifically, but I talked about the market or the market conditions. And expansion and ability to expand, not just from a physical standpoint of the facilities and what they can accommodate and what their capacities are, although that's certainly something that's looked at, but also the potential growth of the community. Because we might have in a small rural area, the system might have capabilities of expansion and might be only used at 60 to 70% of its capacity. But it might be in a location where there's absolutely no expectation, no reasonable probability of any growth occurring or any new customers coming on board. So market conditions, the overall growth of the community. And earlier, if I may, when I was answering a question to His Honor about research and inspections and so forth, I think I explained that we have a list of questions that we go through. And that's one of the things that I specifically ask every seller. How many new building permits do you have over the last few years? Where are your new subdivisions? Are there any contemplated? Are your existing subdivisions built out, or is there growth potential? And then we tie that back to, can the system, as it's constructed, as it exists, can it accommodate growth? So absolutely, those are factors that come into play. And in some of the smaller communities where there's no growth potential, they don't check that box, if you will.
That's all the questions I have here.
Thank you.
Mr. Cooper, I'm sorry. Mr. Cooper.
Yes, sir.
When it comes to the photos from, I believe it was December 10th, and the January 20th, 2020 appraisal report, is it possible to get those submitted by the end of tomorrow?
I don't know, is the short answer. We can check. The photos in particular throw me off because I think that I get the feeling that's going to be a pretty substantial load of megabytes, so I don't know what we'll be able to do with that.
All right.
Picture.
Then let's plan on doing is we'll mark those as commission exhibits, starting with 300, exhibit number 300. And if you can just let us know tomorrow how soon you can get those to us. It may be a situation where we ask you to submit them by the following Friday, by a week from tomorrow. But again, if you can just update us with that tomorrow, if you know by tomorrow.
We will do so. We'll try to do so.
All right. For all the parties, what, do you have an estimate on how long you think the next witness will take?
My part will be very short.
Certainly no longer than the other witnesses that I've.
I would say the same as Mr. Williams.
Okay, so I'll give you, I mean, what's your preference? Would you like to break right now and then have,
I need a short break, Your Honor.
then have Mr. Eisenleffel as the last witness today?
Hope springs eternal.
All right, let's go ahead and break and go back on the record at 4:15. So we're going off the record. Whenever you're ready. All right, Mr. Williams, are you there?
Yes, I am.
All right. And let's go back on the record. Mr. Cooper has called his next witness, and that witness is now on the witness stand. Sir, would you raise your right hand to be sworn in, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Cooper.
Please state your name.
Brian Eisenloffel,
And by whom are you employed in what capacity?
Missouri American Water. I'm the Senior Director of Operations.
Mr. Cooper, excuse me. Can I get you to get like within a couple of inches of that microphone?
Is that better?
Like I said, within 2 or 3 inches would pick it up better.
Okay.
I'm sorry, go ahead, Mr. Cooper.
Have you caused to be prepared for the purposes of this proceeding certain direct and rebuttal testimony in question and answer form?
I have.
Is it your well, let me back up, and that direct is in both public and confidential versions, correct?
Correct.
Is it your understanding that that testimony has been marked as exhibits 5P and 5C, public and confidential for the direct testimony, and exhibit 6 for the rebuttal testimony?
Yes, it is.
Do you have any changes that you'd like to make to that testimony at this time?
No, I do not.
If I were to ask you the questions which are contained in exhibits 5P and 5C and 6 today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Your Honor, I would offer exhibits 5P and 5C and 6 into evidence and tender the witness for cross-examination.
Are there any objections?
No objection.
All right, exhibits 5P and 5C and exhibit 6 are admitted into evidence. Mr. Williams, do you have questions for the witness?
Yes, please. Thank you. Good afternoon, Mr. Eisenloffel.
Hello.
In her testimony, Kelly Simpson says that she was made aware of GIS data relevant to her engineering report. Do you have any knowledge of who made Ms. Simpson aware of that GIS data?
Yes, I believe it was Derek Lynham.
I'm sorry?
I believe it was Derek Lynham.
Who is Derek Wine? I'm sorry, I didn't catch the last name.
Lynham, L-I-N-A-M.
Who's Derek Lineman?
Derek is an engineering manager for Missouri American Water.
He's not a witness here today?
I don't believe so.
Did anyone instruct him to, at Missouri American Water, instruct him to provide that information to Ms. Simpson?
I don't know the answer to that.
Do you know why he provided that information?
I would speculate, and I believe, because he thought it was important to the case that the information contained in Ms. Simpson's report was as accurate as possible.
Well, is there something about the report that she provided earlier that caused him to have that opinion, or do you know?
I don't know the answer.
No further questions of this witness at this time.
Ms. Bretz?
Thank you. Good afternoon.
Hello.
Do you recall writing in your rebuttal testimony that you believe the Eureka sewer system is in good condition?
Yes.
And you believe that today as well?
Yes.
Are you aware of a letter from Christy Savage Clark at the Missouri Department of Natural Resources to Mr. Sabo from December 23rd about enforcement of the Eureka sewer system.
Is that letter the one in my testimony, or is that a different letter?
I think this might be a different letter. If I may, Judge, I'll distribute the letter.
Yes. Go ahead.
Have you seen that letter before?
I don't recall if I've seen this exact letter before.
Could you take a quick minute and read it? You had a chance to take a look at that?
Yes, I did.
What's the gist of that letter?
Well, it's a letter from Christy Savage Clark, who is the compliance and enforcement chief at the DNR, to the city, making them aware of their conditions with respect to BOD and total suspended solid percent removal.
I'm sorry. What was it after solid?
The biological oxygen demand and total suspended solids percent removal.
That's what they did.
Do you see where Ms. Savage Clark writes that because of the pending sale, that DNR will not take any formal enforcement action against Eureka?
I do.
Does it seem to you that a system that is in good condition would be under DNR enforcement action, but for a pending sale?
The information we got from Christy Savage Clark, which I've got an email, which was in my survey testimony, is that these specific issues that she's brought to their attention can be changed and rectified with a simple permit change.
But according to this letter, the DNR is not going to pursue enforcement action because of the pending sale, right?
That's what the letter says, yes.
Okay, that's all I have, Your Honor. Thank you.
Are there any questions from the commissioners? All right. Mr. Cooper, do you have any redirect?
I may, I'm thrown off by getting back to me so quickly. Give me just one moment here. Let me try this. Mr. Eisenhower. No, I'm gonna leave it alone. No questions, Your Honor.
All right. All right, thank you for your testimony.
Thank you.
All right, so we'll adjourn for the day and start back at 9 o'clock tomorrow morning, correct?
Do we want to start with Mr. Kaiser, or
Do you want me to ask that same question? Would you like me to ask that same question? How long everyone expects him to?
It worked out really well the last time you asked.
All right. How about you, Mr. Cooper? How long do you think?
Yeah, I'm not in the best position. I'd say it would be bench questions and obviously questions from staff and OPC that would drive the issue.
Mr. Williams?
I don't anticipate extensive cross.
Same here.
Okay. Then, yeah, let's go ahead and hear his testimony.
Thank you, Your Honor.
So it's Mr. Kaiser?
We would call Mr. Jeffrey Kaiser.
All right. All right, Mr. Kaiser is now seated at the witness stand. Mr. Kaiser, would you raise your right hand, please, to be sworn in? Thank you. Do you solemnly swear or affirm that the testimony that you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
Would you please state your name?
Jeffrey Kaiser.
You're going to have to get closer to the microphone.
Jeffrey Kaiser.
By whom are you employed and in what capacity?
I'm the Vice President of Operations for Missouri American Water Company.
And have you caused to be prepared for the purposes of this proceeding certain direct and sir rebuttal testimony and question and answer form?
Yes, sir, I have.
Is it your understanding that that testimony has been marked as Exhibits 7 and 8 for identification?
Yes, sir.
Do you have any changes that you'd like to make to that testimony at this time?
I do have two.
And which piece?
All right, on page...
Well, let's back up. The direct testimony?
Yes, sir, direct testimony. Okay. Page 3, line 12, 2018 should actually be 2008.
And that's the only change on that page?
That's the only change on that page.
And then is there another change?
Yes, sir, on page 8, it would be line 17, I'd like to insert a sentence, if I could. So after, basically before MAWC, before the sentence starts there.
Yeah. On line 17, is that where you said you were?
Yes, sir. Would like to insert the sentence, the city of Eureka has already undertaken a large portion of this work, replacing the air line between the blower building and the lagoon.
Are there any other changes?
That's all.
If I were to ask you the questions which are contained in Exhibits 7 and 8 today as now amended, would your answers as amended be the same?
Yes, sir.
Are those answers as now amended true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Your Honor, I would offer Exhibits 7 and 8 into evidence and tender the witness for cross-examination.
All right. Are there any objections?
Not as long as they're as amended.
Ms. Brent?
Nothing, no.
All right. Exhibits 7 and 8 as amended are admitted. Mr. Williams, do you have questions for the witness?
Just a few, Judge. Good afternoon, Mr. Kaiser.
Good afternoon.
In her testimony, Ms. Simpson refers to somebody making her aware of GIS data that's relevant to her engineering report. Do you know anything about who made her aware of that GIS data?
My knowledge is similar to that of Mr. Eisenlawful, that Derek Lynham made her aware of that information.
Do you know why Derek Lyman made her aware of that information?
As Mr. Eisenlawful said, you know, we'd like this to be as accurate as possible. Derek lives in that general area, was aware of the GIS information that was available, and he passed that on.
Was that a decision he made on his own to pass that information on?
I can recall having a conversation with Derek about that when he asked me. You know, no real particulars, but, you know, is this something we should let her know? And I believe I said yes.
Do you know anything about why he thought she was unaware of the GIS data?
My understanding is that the data that she used, the assumptions that she made as far as the age of the infrastructure, Derek felt that the GIS data would enable her to have a better assumption as far as the age of the infrastructure.
Is that a roundabout way of saying he believed the age of the infrastructure was different than what she had indicated in the report?
Yes, I would agree with that.
Did Missouri American Water provide any information to Ms. Simpson regarding the DNR violation issues?
Not that I'm aware of.
Why not?
I couldn't answer that.
Do purchasers normally inform buyers of do purchasers normally inform sellers of issues they think they may have with sales prices?
In the context of these, of utility sales,
Well, let's just do sales generally. Do sellers normally inform buyers, hey, we think your price is too low?
I would assume that it would be part of a negotiation.
Well, normally buyers and sellers negotiate prices, do they not?
In certain circumstances they do, in other circumstances they don't.
Well, is this a circumstance, this acquisition of your Eureka system, one where they do?
No, we agreed that we would settle on an appraisal price.
So the sale price was decided by the appraisal price. Is that what I'm hearing?
That's my understanding.
No further questions. Thank you.
Ms. Brents?
Staff doesn't have any questions.
Are there questions from the commissioners?
No questions, Judge.
Thank you. All right, Mr. Kaiser, I have a couple of questions. In your direct testimony, page 6, you make a reference to a report from Bartlett and West Engineers, and it's included as a schedule with your direct testimony, schedule JTK-1, I believe. Yes. That report was prepared for the city of Eureka, correct?
Yes, sir.
And what is the date on that report? I forget. Looks like December 28, 2018.
Yes, sir.
Okay. What information does that report present, and why do you make reference to it in your report?
The question of the most economical way or the options that are available to improve the water quality for the city of Eureka, there are always options on what you can do. The city was looking at doing improvements to their wells that would provide further treatment than what they're currently doing. That's basically what this report laid out. The other option that we believe would be more cost effective would be to run a pipeline down from our existing system, which is about, I believe, if I'm correct, about 5 miles. Mainly the initial cost estimates that we have are about $1 million less to run the pipeline, and the operational cost would be significantly less over time.
Okay. And, but in your direct testimony on page 5, you state that the estimate for that pipeline is $9 million, correct?
Correct.
Okay. How did the company arrive at that figure?
We put together a cost estimate based on the size of the pipeline, what our experience is on kind of a cost per foot basis and the length of the pipeline. Looked at, do we have to run down the highway? Can we run out from underneath the pavement? Those types of things, and then that's how we arrived at the $9 million cost.
Okay. In the Bartlett and West report, if you look at, it's their section 5.2, which is page 15 of 29 of the Schedule JTK-1. It looks like that report estimates the cost to make improvements at $3 million. And I believe that refers to a pipeline to connect to their system. What? Can you testify as to why their estimate would be $3 million compared to the $9 million estimate?
I believe that that's a different pipeline than what we're looking at. And I don't know that that was also I don't believe that solves their bigger problem. But that's
okay. Maybe if you go back a page, that section 5.1.1, scenario 1. So they're talking about a pipeline provided by Missouri American. So how is that different from what Missouri American has in mind under the purchase agreement?
Yeah, I don't believe this would serve their whole system. If you go up another paragraph, it says, desired pressure value as needed if an outside water source were to be introduced. My understanding that, and again, I would have to go back and look at this and confer with Bartlett and West, but that's not a replacement for all of their facilities. That is strictly an additional water source or not a complete different water source.
Okay. All right. Those are all my questions. Mr. Williams, do you have any follow-up?
Thank you, no.
Ms. Fritz?
No.
Can you redirect Mr. Cooper?
Yes, Your Honor. You had the questions early on, Mr. Kaiser, about Mr. Lynham's involvement and his information about age of infrastructure. Just to clarify, when we're talking about that age of infrastructure, are we talking about underground facilities or above ground facilities? No, buried infrastructure, only buried infrastructure. This is, yes. You were asked about why not DNR information being shared. You view the environmental information pertaining to the Eureka sewer system to be significant in comparison to other systems you have seen?
No,
I object to his expressing opinion on that topic, or I am objecting to it.
Mr. Cooper, would you like to respond?
Well, I think it helps explain Mr. Kaiser's answer to the question of why the DNR information, may not have been shared.
I'll overrule the objection and allow it.
So the type of information that DNR has provided, that what I've seen of it, is typical for most water systems. DNR does inspections. They say here's shortcomings. If there are incidences of excursions, you know, if a report is submitted that shows a BOD release greater than what's in the permit, DNR will follow up and say, you know, what are you doing to correct this? This needs to be looked at. I've never seen a sewer system in my 35 years that doesn't need work or doesn't have a letter from a DNR, an Illinois EPA, Iowa Department of Environmental Protection that says this is things you need to do, or there's an upcoming permit that's going to require modifications. The system continues to age. As it ages, things break, events happen, you fix them, you move on, and these are typical in inspection reports and other correspondence. So from our standpoint, what we saw is not significant.
That's all the questions I have here.
Prince? Brent's on. I apologize, Brent.
No, nothing else.
All right. All right. Then, if there's nothing further, let's adjourn for the day and go off the record. Thank you.